Oh, can somebody online let me know whether you can hear okay?
Yes, we hear you very well.
Thank you, Agnes. Okay, so this is,
You have a reverberation in.
is there somebody else who's on? Is that better?
Try again, maybe it's just a little.
Is that better? Yeah, it's a fine line between getting so close that there's feedback and people being able to hear. So, thank you for coming to this workshop. Just a little note about how it's going to go tonight. Mike and Betsy are going to present for 15 minutes, and then staff and hopefully Attorney Dittman will be here. They'll present for 15 minutes. Then the remainder of the time is for board discussion with the workshop participants. We won't be taking public comment at the workshop. We'll be taking public comment during audience business at the beginning of the regular meeting, and usually that winds up being around 7:15. So you won't have to wait too long if you want to give comment. I think there's a sign-up sheet.
Oh, it's David.
Oh, I'm still.
Thank you, Dave. And you'll each have 3 minutes if you don't full time. So everybody clear about that? Yep. Okay. Take it away.
Okay, well, I know y'all are super excited.
Can
to
you
be
come
on.
on?
And
No button.
button. Okay, I'm loud anyway. But I know you're really thrilled that we brought this up again. And it's just been a lot for all of us, but we just want to talk to everyone and try to explain things. We really appreciate you doing this workshop because it's confusing. And so we really appreciate it. We want to keep it short because we think we can do our presentation in about 5 or 6 minutes. And then we can leave more time for discussion and questions. And we realize a lot of this is past history. So a few of you that weren't here before really don't know. We've sent a lot of information. The big packet was sent back in November, and then we sent a small packet last week. And just to kind of give you a little bit, I know you've read this also, but just a little bit of background about us as partners. We have quite a few partners in Riverbend. After the flood, we weren't able to rebuild anything because of floodplain issues. We couldn't read trailers and the mobile home product back because it just wasn't feasible even to do any mitigation. And so we brought it to an outdoor event space, and then we took on some partners. Kenyon and Steve started the We Concept business. Other partners of ours have done a lot of different things in this town over the last 20+ years. We started the Stone Cup, we started the Lions Fitness Center, Westwood Stone, the Dairy Bar, Lions Monet, Riverbend, We Casa, and HB Designs. So we also have served on committees and commissions. 2 have served as trustees, and 3 of our members have been Planet Bluegrass board members for many years. So we've obviously been very involved in the town. We also approximately bring about 15,000 people to Lions every summer with weddings and other events that we do. And there would possibly not be a hotel coming to town unless we did weddings like other people do in the town also. And I'm telling you all this is to give you an idea of who we are as partners and what we've done for the town and how much we love our town. And when you're having your businesses, we put a lot of risk in and have for many years, as have many of our partners. Riverbend was a mobile home park since the 40s, and it was Lion's largest affordable housing area until flood. We loved continuing with Riverbend as affordable housing, and we owned it for probably 8 to 10 years before the flood.
2006 is when we purchased it.
Okay. And we felt like we were helping a lot of people out. We were able to keep the rent substantially below market. When anyone was late on rent, Mike never charged you late fee, and at least 2 occasions he paid people's utilities for them so they wouldn't have their power cut off by the town. After the flood, Boulder County required that we pay back taxes on the tenants' trailers, which we did. We also paid for a substantial portion of the demolition and asbestos expenses for each trailer, although we didn't own the trailers. It wasn't feasible, like I said, because of floodplain issues to bring trailers back. Therefore, we turned Riverbend into an outdoor event center and have hosted many weddings, memorials, and several benefits since 2014. We host fundraising benefits both at the Farmette and Riverbend. And just last summer, we helped raise over $100,000 in 5 months for different nonprofits. As you all know, we've had this ongoing issue with Riverbend water taps, and that's why we're here. We obviously love our town and all want this issue behind us in a cooperative and collaborative manner. We're excited about this board being business friendly, and we want to reach a result that's mutually beneficial to all of us. We feel that we have not been treated fairly in years and want our dealings with the town to be consistent with how other businesses have been treated. We don't think this is too much to ask. We appreciate you listening. And now Michael.
First, we want to thank you for your time and consideration. We really mean that. This is above and beyond. All of us have things we would rather be doing than this workshop. We're all thankful for the amount of time that you trustees dedicate to our community. The amount of information you provided is somewhat overwhelming. We know that. We've asked since the beginning of this issue to have an unbiased third party that will take the time to thoroughly digest all this information and give feedback to the board of trustees about and ourselves as to what they discovered. This request never came to fruition. We request that for this workshop, you take off your trustees caps and put on your unbiased member of the jury cap. I would like to hear from the staff and hope that the board of trustees would like to know if anyone has been able to find where any former board of trustees voted that our 31 taps were a mistake, or is it just a claim that was made by the former town administrator? And if so, what credible evidence do they have? I have been unable to find any evidence that the board voted on this. I have also been unable to find any credible evidence that these taps were a mistake. I found a great deal of circumstantial evidence that these taps were totally legitimate. We're proud of the contributions that ourselves and our partners in the community. We want both our business and our community to be as successful as they possibly can be. And we feel working together is the best way to meet these goals. We provided background information on 4 issues that we would like to discuss today. We feel that the right decision is more important than a quick decision on these issues. The 4 issues we would like to discuss would be the water taps purchased by Mr. Motes in 1973, cash in lieu of McIntosh shares versus CBT shares, our grandfathered rights to purchase 3 taps, which include water dedication, and the number of sewer taps required to service 1 inch water tap, a 1 inch water tap. This is not our first workshop. At the last workshop, the town attorney wanted to direct the conversation towards statute of limitations. We have no intentions of using the court system, so statute of limitations is not applicable to this discussion. We realize the town can prevail even if the facts don't support their argument. Our town prospers through cooperation, not conflict. We think our leaders should have a serious conversation about just exactly what does it mean to be business friendly. We think that being business friendly is a prerequisite to the town reaching their financial goals. As fellow business owners, we would like to thank the board for doing the right thing and allowing Spirit Hound to pay the value of McIntosh water shares instead of CBT shares. We owe Neil an apology. It was Spirit Hound and not Neil who benefited from this decision. My mistake, and I'm sorry, Neil. We welcome the opportunity to work with the board to make clients even better than it already is. We're all here because we love our community. We would now like to hear if the staff was able to find any new or additional information on our taps and to answer any questions you may have. Again, thank you very much.
Thank you.
Thank you very much. Hey, before I turn it over to staff, I do have one question, and that is, are you officially representing the organization or are you representing yourselves? Because I know there are multiple shareholders in Lions Properties. So, yeah, how many shareholders do we have here? Want to raise your hands?
We have 5 out of 6 who represent,
Okay, great. Thank you.
and definitely the majority interest is represented.
Thank you. Just making sure.
And one other one also wrote in this afternoon to Dolores.
Saw that.
Yeah, I forwarded everything I got. Yeah.
Okay.
Thank you very much. I'm sorry for being a little bit late. I was behind First Lady Biden's motorcade trucks out. So they closed down to 25 for a half hour for that. So I apologize for being a couple minutes late. So I want to repeat some of the basic facts that have already been presented here tonight, but I do want to give you some legal background on the status of the water taps and the MOA and some of the the issues concerning the river, what I call the riverbed properties. As Mr. Whip said, this was a trailer home park before the flood in 2013. There are 3 parcels here that are involved. Those are 501, 503, and 517 West Main Street. This flood, of course, destroyed the home park, mobile home park, which necessitated for a variety of reasons a change in use for the property. And so mostly because of the floodplain and it being unable to use for a mobile home park or other residential uses, the owner sought to use it for new uses, namely a wedding venue, and a tiny home resort. Those were not permitted under the R2 zoning, which is what the property was at the time in 2013. And so in order to allow for those new uses, either had to be rezoned or had a PUD had to be placed on the property. And a PUD, for those of you who aren't familiar, is a planned unit development. It allows flexibility in the existing zoning. So it's another way, it's not rezone the property, but to add additional flexibility to the existing zoning of the property. And so the town and Lions Properties, worked on this PUD to allow for these new uses. And, as you might imagine, for this property right after the flood, there's a variety of complexities that arose in order to do that. The flood had changed the property lines quite dramatically. There are diversion structures that needed to be replaced. There's a variety of complicated issues that really couldn't all be resolved in the PUD process. And so what came to exist was a memorandum of understanding, or memorandum of agreement, in this case, MOA. And I'll refer to it as MOA as I keep speaking. And this MOA, resolved these very complicated issues related to the PUD. And I'll get into some of the details as it concerns us here today. But that MOA was executed in 2016. There were a couple amendments to that MOA. However, those aren't really relevant to our discussion. The main one we're concerned about is the original MOA, which was executed beginning of 2016. As important for our discussion here tonight, the MOA is very specific as to the water taps and water shares associated with the riverbed properties. I'll just kind of read through the paragraphs that are important here. First, paragraph 43, the town assigned the use of 1 water share, 1 sewer tap, and 1 water tap for each of the 3 parcels. Those are a little bit different depending on which parcel it is. 501 West Main got a 1-inch tap, 503 and 517 got 3/4-inch taps. But each of them, were basically loaned the use of a water tap and a water share. And in addition to a sewer tap associated with that water tap. Lions Properties in paragraph 44 agreed to, get additional taps and dedicate additional shares if any development was proposed that was beyond what was contemplated at the time of that MOA. So going forward from 2016, if anything new is added to that property, they've agreed in pursuant to MOA to get additional taps and additional shares. In paragraph 45, which is really kind of the crux of this dispute, Lions Properties agreed to dedicate to the town 1 additional share of water acceptable to the city of Longmont. And granted, this was 2016, and so the only type of water share acceptable at that time was the CVT share, Big Constant project. And finally, in paragraph 48, the Lions Property sells the property. They agree to pay the costs of those water taps and shares, which were provided them in the previous paragraph. So essentially, the town was loaning that 1 tap, 1 share, one water and sewer tap, for the time that they own the property. And the event of sale, they either had to pay the money back for those, or get the new owner to pay for that. So that's another contractual obligation of the MOA. I think, as you probably know, disputes arose regarding the dedication of that share in paragraph 45. It was never dedicated, for the period following the agreement. To the contrary, a number of other disputes arose regarding the property, including payment of utility bills. That has somewhat of a relation to this issue as well. In 2018, there was really a lot of problems regarding the property at that point. That included payment of utility bills I mentioned for over $50,000. Failure to maintain a business license, also various violations of the PUD zoning. In the background of kind of all these arguments was this concern of the 31 water taps which allegedly exist. for this property. This argument is presented to the Board of Trustees on numerous occasions, and as I'll get into later, rejected each time. These water taps were existed somehow owed to Lions properties. The town has worked, ever since 2016, really to resolve all the issues related to the MOA and the PUD. And we have been successful in resolving a number of those issues, including the utility bill issue, which was eventually resolved and paid. Unfortunately, however, that water share required pursuant to paragraph 45 was never given to the town. And what ended up happening was that we were actually running up against the clock. As Mr. Whit mentioned earlier, the statute of limitations that attach to all legal actions in Colorado. Those are either 1, 2, or 3 years in civil cases, depending on what it is. And so if you don't bring your claim within that statute of limitations period, you basically give up the legal right to pursue whatever it is you think you're owed. And so when it came to be 2019, we were at the very end of the statute of limitations on the MLA. And so the town did file a lawsuit in May of 2019 against Lions Properties, demanding that one water share. And that was really all that was demanded as part of that lawsuit, initially at least, was that one water share. And so, that lawsuit went on for some period of time, but, in the end, Lions Properties did settle with the town and agreed to provide exactly what we asked, which was one water share. Or in their case, cash in lieu of that one water share, which at the time for a CVT share was $70,000. And at that time, still, even in 2020, which is when the lawsuit settled, only Colorado Big Thompson water was allowed to be dedicated to the town. So even then, there was, even though they had originally agreed to a CVT share, even then there was no option for a share. That ended the lawsuit. I will note that additional compliance obligation of the settlement agreement, which was in your package, was a provision of a Mylar, which is really the last step of the PUD. To this day, the PUD for the Riverbend properties is not truly effective. And that's because all the steps of the conditions of approval have not been met. And the last one is the signed Mylar for the property. And so as we stand right now, the property is still technically in violation of its zoning, which is a problem I think we need to continue to work on to address. So I want to get back into the 31 water taps issue. And I'm there's a variety of different reasons about why, at least from a legal perspective, why we don't think it's a valid argument. The first off, it is not the town's obligation to prove that these water taps don't exist. That's not the way our legal system works. It's up to the proponent of something to prove why the town is at fault, not why the town isn't, or the town to prove why it isn't at fault. Notwithstanding the fact that we have no obligation to prove that we didn't screw up in some way, we've been unable to locate any concrete evidence that these taps ever existed. The evidence that does exist is, purely circumstantial at best. But if you actually look at the minutes, the meetings from the 70s, which are referenced, they haven't looked at extensively now, part of several workshops as part of the lawsuit, and just, us trying to work well with Lions Properties. We can't find evidence where Mr. Mose purchased water taps. He certainly inquired about water taps. He inquired a lot more about sewer taps, and there is evidence of purchasing those. There's no concrete evidence that Mr. Mose ever purchased water taps. If you look at the water book, there is, other than, the misreported entry in 2006, there's not a ripped page, there's no missing information, there's just simply no evidence to back up the fact that water taps were ever purchased. Even if water taps were purchased, however, there's still several reasons why it's really irrelevant for the purpose of the discussion of the water shares that were owed to the town. Getting a water tap does not give you a water share in the sense that is an asset that is freely tradable in the future. That is associated with that property. And it was really only for the purposes of, the town's water agreement with Longmont. You can't go to the open market and trade the water share that comes with the tap. It doesn't come with a tap. Really, that in order to buy that tap, you have to bring a water share to the table. At that point, it becomes the town's. So it's not like it's a freely assignable asset. And that's important because when the MOA is signed, there is no evidence of there being shares out there. Even if they were, they would have already been dedicated to the town. What it says is that the Lions properties will dedicate additional water. It doesn't mention, existing water. It's additional. It's very clear that there will be one additional share. And that any future development on the property will come with additional water. It doesn't say anything about accounting for existing shares. And that's quite intentional because the town believed at that time does now. Those taps don't exist. And even if, they don't come with the necessary shares in this case. And so that's, the short of it. As Mr. Witt mentioned, there is no real possibility for Lions Properties to pursue the town for this. The statute of limitations on a tort, and even if the town was eligibly sued under a tort, which is not, because the Power Government Immunity Act is 2 years. And so the point at which in 2006 or in 2008, when there were a court request I think was originally filed or additional requests were made about this information, or certainly when the MOA was signed in 2016, that was the time to bring this issue to the town through legal means. It wasn't done. Since that time, we've gone through multiple forums to try to resolve this issue, and no additional information has come to light substantiating these taps. So again, it was additionally an issue in the lawsuit, one that did not prevail. It did settle, but the town got exactly what it wanted as part of that lawsuit. And so, at least from a legal perspective, we should really see no basis for the existence of these water taps. Now it doesn't. The board is still free as a political entity to do whatever it wishes, but at least from a legal perspective, there's no basis for these water taps.
Thank you. Clerk Vasquez, is there anything you or Victoria would like to add? Or Director Kaplan?
On my end, no, gosh, I think, oh, I'm sorry. I'm thinking it was it in 18 of when Mr. Whip submitted the core request, and he was here for about a week. I opened every record book I had, every book of minutes. I mean, and we went through everything together. So, and I mean, all of that's been collectively saved and, given to Attorney Dittman. And I mean, it's just out there so I haven't found anything new. I haven't looked because nothing has changed since then, but so nothing really from my end is different.
And for mine, I'm really here more to answer questions. As the board knows, we have had numerous boards seated over this time. We've had numerous town engineers over that time, attorneys. So here to answer questions you would have as we proceed.
Director Kaplan, is there anything you'd like to add?
Same, I was going to say I was here for questions as they come up with regards to the Longmont agreement or water rights.
Great, we have a lot of people to answer questions. Who would like to start? I look directly at you.
Yeah, so, trying to hone in on exactly what we want to really talk about tonight, the 31 shares or the CBT versus 31 taps. Well, actually, that's a question. Is it 31 taps or 31 shares?
31 taps.
It's 31 taps, because I know in 1972, when you bought a water tap, water rights came with it, but there wasn't the specific, like we do now, you buy a tap and a share, right? So were there even CBT shares in 1970?
So in order to buy a tap today, you have to bring a share to the table. So it doesn't come with the
It
share.
doesn't come with it. Okay.
Yeah.
All right. If we have these 31, and let's just say that they did purchase them in 1971, and we lost in court, and we had to come up with 31 CBT shares to basically hand over. We're talking about $2.5 million, right? Because they're what, 85,000 a share now? Mm-hmm. Do we have spare 31 shares? I mean, I know the answer to that. We don't. So we would have to then somehow get a bond, come up with $2.5 million and raise everyone's water rates, wouldn't we?
Yeah, I would say there's a lot of hypotheticals to get there.
Yeah.
But I mean, presumably, yes.
So it's not like we're withholding something we have. We don't have it. Those 31 shares, CBT shares don't exist, right?
There's no certificate for them.
We would have to go out in the market and get them if we were held responsible for them, right?
So
Which is
to some extent, it would be, why would we be looking for 31 shares? Right, at this point, that would be saying a water connection goes in that requires, and I don't like to use taps. I keep trying to get everybody to switch to service connections, and I will continue because we talked with Longmont's agreement is service connections versus taps. But you're really talking about the only requirement there is if we had 31 new service connections go in, then we would be required to dedicate to Longmont 31 service connections or taps as you want.
Which is
So
another-
that would be if something came in that said it wanted it, but otherwise, right, as you mentioned, water rights are not something that's traded or back and forth. They're dedicated to the town in different methods. Some places use acreage and you dedicate water rights. In Lyons, we have service connections where you dedicate water rights. But so that would be the first thing is why would we be as concerned about that, right? There's a piece of property there and the property now currently has a specific size service connection. So I think you'd be looking at something as far as what's changing there or what's going to happen before you need to worry about shares.
Yeah, which is another, I think, important piece of this is that the property that existed prior to the flood, it didn't have 31 service connections for water. It had 31 service connections for sewer, but it didn't physically have the taps.
So they were on a well.
Correct, they're on a well.
Okay, can you talk a little bit about when we did our water share training? We discussed the fact that you can't speculatively buy shares and hold them. And I also know there's a lot of legal language about use it or lose it, right? And so I started trying to research that and got quickly overwhelmed, as you might imagine. But if you think you have water rights from 1970 and you've never used them, where does Colorado state law fall in the use it or lose it?
So it gets complicated as you might imagine, because we're not talking about, if it was a standard water right, a prior appropriated right, didn't use it from 1970. I mean, it's no good essentially. You state engineer come in and say you've abandoned that water right. It's a little more complicated with the shares and the ditch company or shares in the part of the Thompson project, because it's the project that's actually using that water and not the individual shareholders. And so while there technically may be a case for abandonment of that share, it really would be brought as part of the Thompson project or wherever that water was supposed to be dedicated to. So it's a little more complicated, not to say it wouldn't be declared abandoned, but potentially if it was never used, it could be subject to abandonment.
Okay. Let somebody else go. More questions?
Do you want to respond?
I would love to respond to what the attorney had to say.
Just a couple minutes though, because I want to make sure that we get
Okay.
trustees.
Just a couple of minutes. Part of the reason that we placed asked for an unbiased third party is because he covered a lot of material, a lot of which we totally disagree with. We think very much that what he said is misleading and incorrect. And I think it's inappropriate that we take what he said and run and discuss with it when I think a lot of the information I provided with you to you people is obviously in conflict with what he's saying. And I think we're going down a road of discussing stuff here that is really not the crux of the problem and what's really applicable. And I'd like to get us back on course with what I really think we need to be discussing here. We're going to waste our hour and I'm sorry.
Well, the attorney was answering the trustee's question.
I understand, but we only have an hour and
So let us move on then.
Okay.
Okay, who else has questions? Yeah, please.
Well, could you then clarify what it is you want us to discuss or shoot directly
let
right
me
now?
give you a little bit of history on the 31 taps to begin with. So Mr. Motes bought this property in 1973. The town of Lyons did not sell sewer taps at the time. The town had a sanitation district. Mr. Motes went before the sanitation district and bought 30 sewer taps. We have a copy of the minutes from the sanitation district. He bought 30 sewer taps. We got a copy of the building permit. He paid roughly $40,000 for the infrastructure to do all of this. That's pretty much documented. He went before the trustees on several occasions because they're the ones that sold water taps. He went before the trustees to talk about, he upgraded the electrical system at Riverbend. I don't know what the expense was, but it was substantial. He changed the zoning at Riverbend in 1973. In 1972, the price of taps, and all through these years, when you bought a tap from the town of Lyons, low water dedication came with it. The price of a tap in 1972 was $250. Mr. Motes saw this price go up to $350. And in November of 1973, it was going to go to $700. Mr. Motes bought, and this is the one piece of evidence we don't have. What we do have is he bought these in 1973. When the town entered into their intergovernmental agreement with Longmont in 2003, these taps were included in the contract with Longmont. It's documented in the minutes book that the town staff had done a thorough investigation. They had determined that these taps were legitimate. They were included in the contract with Longmont, and it was all cool at that time. We purchased the property in 2006. Mr. Cinnamon decided 4 months after we bought the property that 33 years after these taps had been entered into the tap book, they were a mistake. The reason he said they were a mistake is because the taps weren't physically hooked up, so they couldn't exist. There was no water main on the side of the property. The fact is, Mr. Motes bought these taps before the price increase, knowing that when a water main came to the property, he was going to have to physically hook up. He's not the only one in town that did this. We found other examples of people who bought taps for many years until the water line came to their property, and then they hooked up, and the town's honored it. They set a precedent. Nick Angelo was one. He bought a water tap many years before a water line, before the subdivision was put in up there. And years later, he got ready to hook up. The town couldn't find his records. He fortunately was able to find a canceled check that said, here's the check that I paid for these taps. He paid $3,000 one day before the tap rate went from $3,000 to $3,500. The same as Mr. Motes. He bought it just prior to an increase, but he didn't hook up for many years. The town says, well, you have to buy one. He says, I've already purchased it. Fortunately for him, he had to cancel check because the property hadn't traded hands. So our taps were documented. They were approved. They were in the contract with Longmont. We have been able to find no evidence that they were a mistake. A great deal of evidence. Mr. Motes went before the trustees on multiple occasions, said he wanted to buy taps. They referred him to what they call the water committee. We haven't been able to locate any minutes from the water committee, but the trustees basically said the water committee will take care of it, Mr. Motes. And the page was put in the book, and Administrator Cinnamon says that in his letter to Longmont. He says, well, I found this page in the book for 31 taps, but it was a mistake. So the only evidence we have that tap was there, that page was there, was the fact that I saw that page, and Administrator Cinnamon in a letter to Longmont said that page existed. But we don't have that page because it was removed. Now, he says it was sewer taps. Well, there was already a page in the sewer book, which again was a totally separate organization, that had 30 taps. So why would he buy 61 taps? I don't understand why he would buy 61 sewer taps.
Okay. Can I ask you to pause for a second?
Yes.
I'd like to go back to Trustee Dottie's question. I mean, what are your desires here? Are we going to argue? Are we going to discuss the 31 taps, or are we going to discuss the CBT share Macintosh?
Let's discuss
you
the
said
Macintosh.
you said we were going down a rat hole, but then you continued on that.
Well, because I really think that it wasn't complete. The information wasn't near okay. I wanted to complete the information. Okay, let's talk about the Macintosh shares if you like.
Well, could you first at least state what is your expectation with these
Is the
31?
four things, the 31?
Yes. I mean, what do you feel would be reasonable?
We made it clear from the beginning that we will never use 31 taps on that property. What we wanted to do with one of those shares was dedicated for that. When we signed the MOA, we never discussed these taps. These taps were never part of the MOA. Never discussed. In fact, the town didn't even think they existed at the time we signed the MOA. They didn't discover till later that they had been removed from the tap book. So they're never part of the MOA.
Should we concentrate on the MOA then?
Yes.
Well,
Okay, all right.
I want to pause for a second, and I want to give Brandon an opportunity to reply if you wish, if not.
The only reply I would make is that again, there's no evidence that the taps existed. There's no check, there's no resolution, there's no where the minutes that 31 taps were purchased. We have that for the sewer. We don't have that for the water. And you know, without that, I don't see how we can disprove a negative. You know, that's the issue from the towns, from my perspective, is that if we go to a court, they want to see actual evidence of where these water taps have ever existed. And at least as far as we've looked, and we've looked extensively, there is no actual evidence that the taps existed, only the conversations about water taps, but nothing concrete enough to say, yes, you are 31 taps.
Trustee Elson.
So I still don't understand what the end game is from 31 taps. What are you trying to get? So there's 31 taps, you said you don't want to use all 31 taps.
Right.
So what are you, well, I heard you want to possibly transfer one, but what are you looking to do with it?
We can move on. What we would like to have is, and all this fits together, but what we're saying is, we think we should have rights to whatever taps we need, and all the rest we're more than happy to dedicate to the town. But given our time constraint, we can move on to some of these other issues. But I think it's really hard when a staff member removes a permanent document from their town records and it no longer exists. And then we say, well, there's no evidence that it exists, but yet it clearly was there because
Okay,
it didn't.
Mr. Whip, you said you'd like to move on,
Okay, let's move on.
so let's move on.
Okay. Let's talk about the water dedication. The reason that we didn't dedicate earlier was because we firmly felt we had rights to these 31 taps. By the way, these 31 taps, there was only 21 CBT shares that were dedicated with these 31 taps. They used a formula of 7/10 of a CBT share for the purposes of the mobile home park when they entered into them into the contract with Longmont in 2003. So it was only 21 CBT shares and 31 tap for the record. So we had hoped to dedicate one of these to cover the share that we had agreed to the MOA. The MOA that we signed wasn't the one that we negotiated. We sat down and negotiated it. And we negotiated with Mayor Sullivan. Betsy and I left town for Mexico. She left for Africa. Jerry Moore, one of our partners, called me in Mexico and said, Mike, 2 other trustees have called me in. They said that they're not going to honor the MOA that we negotiated with Connie. And it's like, well, they wanted to enter a paragraph that said upon selling the property, we were going to have to pay for these taps that we had negotiated. We're just going to be part of our arrangement. But that we ended up signing it because our temporary zoning change was going to run out. We were told we had to quit booking weddings if we didn't sign. We couldn't afford to quit booking weddings. So basically we signed under duress, even though this new part that says we have to pay for them was added after we had negotiated. But we signed it. It's legal. We signed it. I understand that. The reason that for a long time, we insisted we want to dedicate a share of water that we already own. By the time we got around to dedicating, the town was accepting McIntosh water. Keep in mind, our MOA says water acceptable to Longmont. It's not what Lions will accept. The MOA says water acceptable to Longmont. I talked to Dale Rademacher in the water department in Longmont, and I says, would you accept McIntosh water for dedication? And he says, yes, we will. He gave me the name of 2 brokers. I contacted these 2 brokers. One of them said, I just can't find you any McIntosh shares. The other one said he could, but he didn't come through in time. And we were getting down to the deadline with the town, and they said, we're going to make you quit booking weddings again if you don't resolve this. So we wrote the town a check for $70,000, but it was what CBT water traded for. We did that because we could not find McIntosh water, but we looked for McIntosh water. We couldn't find it. It was a situation quite extremely similar to what happened with Spiridon. But again, according to Longmont, they would accept our McIntosh water. And that was the determining factor. Is the MOA says Longmont determines it, not the town alliance. So that's why we were unable to find it on the open market, and so we paid for CBT water rather than McIntosh, like they were allowed to.
So what is your ask?
That we change it so that we just we could dedicate McIntosh Water. The town bought 7 shares of McIntosh Water with the $70,000 that we wrote a check for. 2 shares would honor our agreement because 2 shares is what Longmont would have accepted. 1.4 shares is actually what they would have accepted, but you can't be part of a share. So the town has 5 extra shares of McIntosh Water that they wouldn't have had we been treated the same as Spirit. That's what I'm asking, is just to be treated as other businesses.
Thank you for that answer. Do we have any other comments, questions from the board? Go ahead, trustee Dodge.
Yeah, so I'm just trying to understand the difference here between Spirit Hound, for which we were here for earlier last year, I guess, but during our mandate, and Riverbend, which I think was, I'm thinking of the amendment to the IGA signed. Yes. Go ahead, Brandon.
Yeah, so the $70,000 paid by Riverbend was specifically to settle the lawsuit we filed against them. That lawsuit didn't say dedicate McIntosh shares. It said pay us $70,000 or gives a CBT share. And, you know, we were willing to continue that lawsuit. We think we would have won on the merits, but what we asked for in the complaint was 1 CBT shares cash equivalent. That's what we got, $70,000. There was no option to give McIntosh shares to satisfy that lawsuit.
So I guess what I'm trying to understand is our intergovernmental agreement with Longmont, the city of Longmont, regarding water shares. So with, I remember with Spirit Hound Distillery this past year, we were able to accept because of our agreement that was amended in 2019, I believe. But before that, was it
2021.
2021.
When the town on its side put into place the ability to accept McIntosh. Prior to 2021, the town did not accept McIntosh.
Right. So actually, before 2021, McIntosh wasn't an option.
It was not.
It was the Longmont.
But it was for the
I don't, do you want the specifics? Again, Planner Kimmett and I
if you can do it briefly, that would be.
were just out with Longmont Friday. So just to be clear, in that time, we had to go to Longmont. They did have to amend the agreement to accept Lake McIntosh. We were just currently asking them if they could accept other water, and you can look at other water, but the agreement with Longmont would have to be amended. So that was part of the process to be able to accept Lake McIntosh. So maybe they thought they could take it, and maybe they were stating that, but until the agreement was amended, just Friday, we were told we could not accept other water. The contract says other water acceptable to Longmont, but that has to be gone through the documentation process, according to Mr. Houston and Mr. Lowry. Just that's how they say the agreement has to be done.
Brandon.
Yeah, I will say, you know, under the MOAs of this today, any future dedication of water, they've written more development beyond what was envisioned in the MOA originally, that would potentially be eligible for McIntosh water if they went through the process. But you can't change what the outcome of the lawsuit was.
Was the lawsuit actually for 70,000 or was it for water dedications?
For specifically, if you read the complaint, specifically for water that comes.
I thought we settled that at the last minute, and I thought you were constantly going for water dedication. And that's because, and again, all I can tell you is what the Ratmaker told me. He says, yes, I will take McIntosh water mine.
But
That's-
And that's all I can say.
their portfolio takes a variety of waters. And so if I were to ask Dale, do you take Lake Mac? He's gonna say, yes, we take Lake Mac.
And the MOA says we can dedicate what
But-
Longmont says, not what Lion says.
But-
Okay, so this is past history. We're looking at moving.
It's all past history. Yep.
Okay, I want to see, we do only have, you know,
I know. we don't
5
have
to 10 minutes left, so I want to see if there are other questions from the trustees. Please.
It is still not clear to me precisely what you're asking.
Well, it was, the document that we sent on Thursday listed everything exactly what we're asking for. Let me dig that out. It's what you got in your packet. Yeah, it's in your packet.
A lot of it has to do with the tiny homes, versus 2 houses. It's all explained very, very detailed in there.
Yeah, I tried to give you a good reader's digest breakdown exactly what we're asking for so that you could read it in your packet and we would have that out of the way because we have such limited time. But it's a 3-page document, but yeah, I've provided it for you.
This is what I would say I understand at this point. Obviously, going forward, we're gonna steer everybody we can to McIntosh shares that we possibly can. CBT shares have gone through the mill. And right now, I think the only people in town that have to buy a CBT chair is a core market R1 single family home. Other than that, we're trying to get everybody else in Macintosh. Obviously, you know, what happened with Spirit Hounds is because at the time it was very clear to us we could do that. What happened 2 boards ago, we can't speak for them. The other thing that you had in there that I'm actually excited about, something good that I hope comes of this, is you talked about what water shares you need for tiny homes. I would like to push the limits here to make sure that a minimum amount of water shares are needed for tiny homes. When people are trying to basically live a simpler life and use less resources, we should help them and not force them to buy full water shares if they're going to have a much smaller home. I mean, that's all makes sense to everybody, I hope. So I think that's good. That's something that I hope comes out of this. But going forward, I don't know what can be honored with those 31. I don't know how you can keep water rights from 50 years ago and expect, because that's $2.5 million of water rights with their CBT. So going forward, yeah, I know, but going forward, if you took it to the argument to its extreme, it is $2.5 million of water rights.
Let me,
We don't.
I understand, Greg.
We just don't have it.
We never wanted to damage our town financially. Trust me, we know that. And Attorney Dittman's right. These shares are only worth that amount of money to the town. We can't sell these taps.
Yeah.
They're assigned to this property. We can only use them on this particular property. So they only have value to us to the extent that we would actually develop on that property. He's very correct when he says we can't market them, we can't sell them, we can't do anything else with them. But they do have value to this particular property, and they were purchased. The only reason that they aren't in the books is because somebody removed the payment.
Yeah.
I know. But
Okay, I'll stop here because I know the trustees know that.
And Greg, I want to correct something. You were talking about the water taps for tiny homes. Our request is about sewer taps. They're providing a lot more sewer taps to the tiny homes than would be required to most other uses. And we just feel like the number of sewer taps should somehow line up with the amount of water that's being used. And we feel like the number of sewer taps there's 8 sewer taps being used to service a 1-inch water tap, which I don't think anybody else in town is required to have 8 sewer taps for 1 water tap. And that was our concern there is we thought it should match up a little better because you're absolutely right. This is affordable housing. And we should try to keep it.
It's not affordable housing, it's a tiny home as well.
Okay, well, anyway, we just are trying to make an argument that there should be a correlation between the amount of water that is being treated at sewer plant and what you pay to treat the water. And in a business friendly aspect, as a business shouldn't have to pay multiple times what a resident should pay is what we'd like to say.
And we cost versus tiny homes and other people's yards. That's what we need to be specific
Yeah,
about.
that's
But in your packet, the 4 are the asks. So that's why we didn't talk about it a lot there that we sent twice. One other thing I want to say real quickly, because I know we only have minutes, but Attorney Dittman mentioned at the very beginning of this that they were having a hard time with getting utility bills from us years ago and about up to $50,000 or $60,000. We tried, and Mike can explain this better than I can, or Kenyon could. We tried for many, many months to get a meeting to explain what the utility bills. That's why we didn't pay them. We never got a meeting. That's the only reason. I don't want the new trustees to think we weren't paying our.
So again, this is past history. We're looking forward, appreciate the response, but I want to keep us looking forward instead of rehashing everything.
They had
that's
not
gone
heard
on
that,
for
so.
multiple boards. Okay, so we do have a couple minutes left. I want to know if you all have any closing comments, and then if staff has any closing comments.
I wish we truly had the time to go into these issues as deeply as I have. I've spent so many hours going through the town's records. I'm totally convinced that when the town entered into their agreement with Longmont, these taps were considered legitimate, just as the town did. On these other issues, all I can say about the Macintosh is Longmont, our contract said, accept it with Longmont. I called Longmont. They said, yes, we will accept them. And that's all I could base it on. If there's other circumstances above and beyond that, with my conversation with Longmont, they said, yeah, that's what we'll accept if that's what your document says. And Dale Rademacher was the gentleman who told me that. That's all I can say about that. I wish that we really could, I wish you trustees could really see everything clearly that's happened, because there's a lot of things that are quite misleading.
Thank you. Do you have any closing comments?
No closing comments from me.
So before we adjourn for a break before the regular meeting, I want to thank you. I want to thank you for coming. I know that multiple boards have heard this before. You've been to multiple workshops. This is the second one. This is the second workshop. Philosophically, I believe that everybody in the community who wants to come before the Board of Trustees with an issue should be allowed to do so. And so that's why we're all here. We'll take a 10-minute break. We'll come back and we'll begin the regular meeting at 7 o'clock.
Thank you.
Thank you.
Okay, we're on.
Are we ready?
Yes, ma'am.
You're ready, okay. I will call the Monday, April 3rd, 2023 Town of Lyons Board of Trustees meeting to order. Can you have the roll call, please, Rebecca?
Yes, Mayor Rogan,
Present.
Mayor Pro Tem Farrell. Trustee Elson. Trustee Dottie. Trustee Edding. Trustee Delman. And Trustee Williams.
If you please rise for the pledge of allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice.
Thank you. Before I read the land acknowledgement, just a note, we're hearing that it's really difficult to hear us from online. And so when you speak, please use the microphone and get close to it so that the folks online can hear what we're saying. And don't worry, I'll remind you. We must acknowledge with respect as non-native people that the land on which we stand, live, and learn is the traditional territory of the Ute, Cheyenne, and Arapaho peoples. We also recognize the 48 contemporary tribal nations that are historically tied to the lands that make up the state of Colorado. Is there a motion to approve the agenda?
So
Thank you. Is there a second? Thank you. We need to use our microphones. Is there any discussion? Okay, call for the vote.
And that motion passes unanimously.
Thank you. We'll take a reflective moment of silence. Thank you, everyone. Now is the time for audience business. You will have 3 minutes to address the board. Please state your name and address for the record. We'll do in the room first. I think Mr. Law signed consultant. Come on up. Nice to see you.
Nice to see you. Thank you, everyone. And thank you for the time and the effort around the workshop earlier today. So I just had a couple of, I'm sorry, Kenyon Wong. I live at 1104 4th Avenue in town. So again, thank you for your time and thought on all these issues. I think leaving that workshop, I think really what I'm feeling as a partner of Lyons Properties is the past is the past. The legal side is the legal side, and that is what it is. I think what we're asking for is we cannot have this discussion between the two parties any longer. It's made no progress in terms of several of these issues, MOA issues and so forth. And what I think we're really asking for is an opportunity to bring in a third party that might be able to hear both sides. And we're willing to live with the results of that. So I think I just wanted to kind of say, in the end, we want to put this at rest. We don't want to be angry. We don't want to be fighting. We want to move forward as well. And I think, as I said, there's just no way that we can have this conversation. We've all said what needed to be said. We still have strong opinions on both sides. We're not asking for a legal precedent. We're just asking you to consider what's happened to us in the past and how we might be able to move going forward. We feel like we've had a lot of added expense, specifically about the sewer taps, and I wanted to reference where some information about that as you're talking later about that in the meeting. So at the time when all this was being cited and so forth, Engineer Blankenship suggested that the tiny houses were really all just small houses. And he decided that the precedent was going to be that each 4 tiny houses needed a sewer tap. We had asked, the meeting that was asked for several times was to explain and show us some kind of precedent where that was coming from. We were just kind of handed that number. We wanted to understand why it was, because as Mayor Rogan pointed out earlier, this was not a community. This was a 50% occupied short-term resort using tiny house technology and efficient water and electric and other systems. I think it's important to remember that at that time, there was no BOD charge. So I think that in an effort to make up for some of the shortcomings in the sewer facility and the upcoming BOD changes, it was suggested that maybe we do this 4-to-1 sewer taps. So we have been paying since 2015, we've been paying for 8 sewer taps. Only one of those were also being charged under the municipal code for the usage of the actual water that's being used. So there's 7 additional water taps. And actually for the first 4 years, we were paying BOD medium contributor, which we, again, if we were even residential, we wouldn't have been charged that, but so we were actually being charged BOD and 8 water tap or sewer taps. While we're the only business that we know of, or the only people in town who have multiple sewer taps for 1 water tap. And as Attorney Dittman said earlier, the MOA says that we will have 1 water tap, 1 sewer tap, and 1 electric tap. So I'm not sure.
You're gonna wrap it up.
Yeah, I'm just asking. We've paid literally thousands of dollars since 2015, and we pay almost $80 per 1,000 gallons of water.
Mr.
So
Waugh, your
I would
time
like-
is up.
thank you.
Thank you. Is there anybody else in the room who'd like to speak? Come on up. Name and address for the record, please.
Betsy Burton, 1308 Apple Valley Road. Thank you again for the workshop. Obviously, 15 minutes is not enough to explain all this. Because the packet was very long, but last Thursday, we sent a 2.5 page page to be in the packet. And these were the asks. But everybody kept asking what we were asking. So I'm going to now say what we were asking. One is the third party mediator, which I think would be fantastic. We've asked that for quite a few years now. And then the last of this page here says, in summary, we are requesting that this board amend the MOA and remove the paragraph that requires us to pay for these tax and water shares upon the sale of the property. This would compensate us for the easement we granted the town as per our conversation with Engineer Blankenship. We didn't have time to talk about that tonight. We dedicated a part of the property, a big swath of our property, for the water main to go through. Blankenship said we'd be compensated. We never were. So that's part of the ask. We also request that you transfer 5 our shares to us that we purchased with our money. This way we would be treated the same as Spirit House. We would like to see the number of sewer taps that we possibly required to have reduced from 8 to 2. Because this was also in our packet. Weak CASA is the equivalent of 2 homes. Weak CASA also brings $40,000 of lodging tax to the town. 2 homes do not, it doesn't equal for 2 homes to use as much water and sewer as all the weak CASA homes, because they don't live there. There's really no kitchen. There's no disposal, food disposal, or anything like that. So we just thought that was fair, because we bring $40,000 of weak CASA. And then, and this is a side note, we also pay $50,000 worth of taxes every year at the Riverbend property. So we would just like to see if we could be treated, if the weak CASA tiny homes could be treated the same as 2 homes, which don't bring in the revenue that our property brings to this town. So those are all the asks that were in there. So I hope that makes it more clear. I hope y'all got this.
You did. Yes. Thank you very much. Appreciate it.
Appreciate it.
Anybody else in the room like to comment for audience business? Okay. Anybody? I'm on. I see Mr. Sparks. Please state your name and address for the record and go right ahead.
Thank you, Mayor. Thank you, trustees. Gil Sparks, 2169 Apple Valley Road. On tonight's agenda is the second reading of the purchase of 2157 Apple Valley Road by Kay and myself. As I said at the last meeting, we are very grateful for all the help we've gotten through this process. We appreciate the ability to work with the town to bring this to fruition. We could not be there tonight because we are now in Arizona helping with the follow-up to the birth of our second granddaughter last Sunday. So just want to say thank you, appreciate it, and assuming that the board does approve it at second reading, We have left a earnest money check with Laura Levy's office so that this trends. Thank you.
Thank you, Mr. Sparks, and many congratulations on your expanding family. Anybody else online care to comment?
And I'll just note for the record, I received those 4 public comments. I sent them to the board and they'll be attached to the minutes.
Thank you. I don't see anyone else, and so we will move on to the Boulder County Sheriff report.
Thank you. Sergeant Sears is unable to attend tonight, but he did include his March statistics in your packet. So I don't know if there's any questions regarding that. Other than that, I have not heard of anything of serious nature in town. It does appear those SWAT cameras are certainly tagging people from all over that are either wanted for something or have a stolen car. And it's been very helpful to our law enforcement.
Okay, thank you. And so next up, we have the administrator report.
Yes, there was a lot of information in your packet this time, but I just want to highlight a couple of things. I want to make sure the board knows that the mayor and Director Mitchell and myself have met, and we're trying to revamp our communication strategy a bit. One of the things that we have started producing is called the Board of Trustees Recap. It's a 1-pager. There it is. So after every meeting, we're going to try to get that out on Tuesdays, kind of a synopsis of what action the board took the night before. Oh, trustee would like to see if he was out of the country. So we are going to be doing that, and we will be sure to include links to each item. So people who want to know more information about a specific topic can go right to it. But that is something you should be seeing. We will do our best to get it out on Tuesdays. There may be an occasional that it's not, but that's our goal. I did have several items in my administrator's report that staff just could use a little direction requested. One of those is this lease agreement. As you know, we've been working on that for months to try to make that happen. The staff did get the Brown Public Works building emptied other than the file room well before the deadline that we were trying to meet for April 1st. But it's kind of gone radio silence with leave. And so Director Cosgrove's getting a little nervous. April 15th is when the spring season really starts taking off here. And the Lions ditch is turned on, irrigation starts, all of those things. He is going to need 2 trailers, as we've talked about, to be able to not have this building in town to keep equipment in. And we're just not sure if we should move forward with that because that was not budgeted. It's about $22,000 worth, or not, because it doesn't appear there's a lease on the horizon. Or do we just our staff spent a lot of time thinking on that building as well as the sheriff, and now it's empty. Do we start utilizing it again, or do you want us to purchase these trailers, which we do not need if they're not going to.
So I'll just add a little bit of information.
Thank you.
So the lease is with the Leaf attorneys. There's been a change in the board leadership at Leaf. And we don't have an ETA on when we're going to get that lease back and what changes they're going to be requesting. So we don't have any insight. So my question is, I have 2 questions. The first question is, what would it take to move our equipment back into that building? The second question, 3 questions. The second question is, when's our kind of drop dead date for purchasing trailers? And then the third is, does the board want to put a deadline on this and tell me, for example, you have until April 15th to decide to get the lease back to us with any requested changes because we need to.
So in regard to the equipment, we certainly wouldn't bring back everything, but I think what we would do is park all of our mowers back in there until we have a better ETA of if they're going to take the building. And we would probably start that now. So that they've all been serviced over the winter, ready to go to work. So, because we only have, they'll have to be brought in without a trip, with just what we have now, the process right bringing 4 or 5 trailers. So that's all. We would probably just bring in that, maybe one tool box set up for any maintenance they need to do, and then all of our weed whacker sheets. I do see that Director Custer's on there.
Do you want to comment, Director Custer?
Yeah, I'd be happy to. I think Administrator Simonson covered it pretty well there. It wouldn't take us a whole lot to bring our in-town equipment at the very least back in, so we would not have to trailer it. And we'd probably just bring, like she said, some tools in so we could maintain it should we need to in town. And the rest of it is completely cleared out at this point and cleaned, so we'd probably just leave everything else. But yeah, I mean, typically we start up second or third week of April with some of those tasks, and so I guess the sooner we know one way or the other, the better.
Yeah, I think we all agree on that. And what about the trailers? So it sounds like there's a deadline to order trailers. They're holding them.
I'm in charge.
Well, they were gonna hold them. This is the second round we got. One of the first 2 that we got estimates on sold, and this is the time of year where they sell pretty quickly, and there is one local dealer that specializes in the ones that we're getting. Otherwise we have to go pretty far away to source these. So that was our concern there, is that these are at this time of year go pretty quick.
So my inclination, and I'll let you know what you think, is to, since there's no ETA on getting the lease back, move the equipment back to the building that you need, at least to kick off the season. And then how do we feel about giving Leaf a deadline of April 15th? I mean, they've had a lease for a couple of weeks now, called their attorney. And when it went to their attorney, we were all in agreement, so there shouldn't have been any surprises. So how do we feel about telling them they have until April 15th, and then we can take it up at our April 17th meeting?
That sounds reasonable.
Yeah.
And I want to thank the staff for all their efforts.
Yeah. Thank you.
April 15th sounds good to me too. I don't like the plan of moving those trailers at that price now. I mean, might not be a bad thing to inform them of that. We're moving back now because you really didn't give us an option because you didn't get back to us. So I think the deadline 15th is more than reasonable.
So the subcommittee will notify your liaisons and I'll notify the staff liaison. That sounds okay. Yeah, that sounds great. Thank you. The next item, and this came up quickly, and they need an answer by April 7th. Otherwise, I would have put it on the agenda. If you recall, we agreed to be part of an opioid settlement that the state negotiated a settlement with some of the major opioid producing companies. And we passed a resolution saying we're going to be part of this Boulder County Regional Group. But then for some reason in the resolution, it was very specific and it listed just the 2 companies they had settled with. Well, since then, they've settled 5 more. And so I need to adjust that resolution to be part of this next group. I just need a nod from the board that you want to, and I can sign up the participation forms. Then what I would do is bring back something on consent agenda ratifying that decision next time, because they need an answer this week. if we want to be part of 5 more settlements.
Yeah.
More money.
More money.
And we would ratify it such that it would just be in any other future
change it.
settlement. I mean, the original one, one of the first ones to do it, actually, is based on the form, basically that was out. So.
Are we good with that?
So go ahead and sign there's 5 there's a participation form with each.
Can I be clear? We'd like more money, please.
So, okay, I'm gonna go ahead and sign that then on behalf of the town, or if it
Yes.
requires you all like to know tomorrow. And then we'll bring back a resolution ratifying or amending that previous resolution, so it's more broad in case there's futures. Okay, the staff have been meeting with Lions Creative District. They thought they might be interested in taking the visitor center and helping us with staffing that this summer. They don't think they're quite organized yet to do that, though they do want to pursue a lease with us. So we will move forward now as staff and try to get that staffed for the weekends at least for the summer season, while we work on a lease agreement with Leeds between the attorneys. I did put in here Boulder County Mental Health Roadmap at one point that we were making that a priority. Cherie Moreau with Leave has been representing our community at that task force. And so I have listed what they have identified as their 6 mental health programming priorities for the next 15 to 20 years. So I just want to keep you in the loop on that, so you know what's going on. Also, April always starts a busy time for us, and I just want to make sure the public is aware that April is our discount dog licensing month. And so get a copy of your rabies vaccination, and it's a little 1-pager you fill out to get your dog licensed. It is a requirement in town to have your dog licensed, and those fees go toward helping with the dog park maintenance. And also it is very, very helpful when your dog happens to go at large in town. Most people will just bring them here instead of, calling the Humane Society where they get a traumatic day. So please get your dog licenses going this month for the fee of $20 for the first dog and $15 for the second, only for the month of April. So that is, we encourage you to do that. This is the first month that we're opening up golf cart registration. This will be a free service for the community this year while we get used to this. There's again a pretty simple online self-checklist that you're aware of the rules, you're aware of where you can be, where you should not be. And then you'll also get a sticker that you're already registered. That will help us in those situations where we need to move a golf cart or someone runs out of power somewhere. That's not very convenient. The code compliance or the sheriff can identify who that is and make your call. Will be helpful. And then our 2023 parking passes are available if you haven't gotten that yet. 1 per household to be able to park free in any of our parks if you are a utility customer of the town. And then I did put in the recommendations from regarding the Broncos money. Don't know if there's any feedback from the board on that, but they did get input from Park and Rec Commission, staff, Student Advisory Commission on how to spend that. And if there's not feedback, we'll pursue what they recommended.
Any feedback on the whopping $60,000?
I have a little bit of feedback. I really like the idea of obviously focusing on youth and maybe I like this idea of camp and also activities, the sports trial. Of course, I just want to give everybody a heads up that during the time I was on the PTO board, we annually funded Average 4 to come to the elementary school and do a day of mountain biking and rock climbing and like four sports. So before following up with that, I would just check in with the Lions Elementary School to make sure that isn't already something planned for this community. So I'm doubling up.
That's a great one.
Thank you. And then I just want to, because there was so much information in there, also in your packet this time, if you want to spend a little if you want extra time, Director Cosgrove did put our 2023 Parks Operation Plan. That goes everything from security to hours to what our park hosts do. It's very detailed. And so if you have people inquiring, it's a great tool, document to send them. Also, there is an update in there regarding the Martin parcel fire mitigation. And our hazard mitigation coordinator has worked with Left Hand Fire Protection District and the Lions Fire Protection District to identify a 60-foot buffer on the north and west sides that they think are the most critical to get cleaned up so that a fire doesn't have as much fuel to then attach the adjacent to the town. So we're planning to move forward and spend $25,000 of your fire mitigation budget on that. I know the goat people were here today, so that will be starting as well. But there, in case you have questions on the Martin parcel, that's in there as well. So there's, and then the Boulder County co-responders who are our partners of mental health, responding to different emergency calls, also put in their newsletter this month. There's a lot of information on there.
Yeah, there was.
Yeah.
Questions for Administrator Swenson?
So I just have a couple of questions. So one, our Housing and Human Services Commission meeting on Monday, I'm going to be following up with the co-responder to find out why there was such an increase October, November, and December. Maybe that's something the sheriff could have responded to tonight, but since she attends those meetings, I'll ask her directly and maybe.
So the typical sad months,
Okay.
seasonal affective disorder kicks in. Holidays are very difficult on people's mental health. I would assume that's part of it. Plus she was here full time now. We've never had that service before.
That could definitely. And I also want to volunteer to be on the committee of board members who will be working with town staff on the use of the visitor center.
Thanks. Thank you. Anything else you want to volunteer for?
Well, actually, I want to follow up with the Economic Vitality Commission and the Chamber of Commerce regarding the 40 local businesses that are not licensed. And just figure out how can we promote that going forward? How can we, what kind of system can we have to kind of procedure or policy or how do
Do you want to talk about that?
Well, we can address it. The code compliance, Zach Burgess is going to be the person who's been sending them notices. Business licenses are actually supposed to be renewed before the end of December, the year before, so that they're up and on the wall by January 1st of 2023. We do remind people it's a fairly easy application. It's all online. It's $25. And it's, well, it was 25 during COVID. Is it back to 50? No, it's 50. It's $50. And unfortunately, at the beginning of last month, there were still over 100 people without them. So they have responded, but we then after 90 days, after 3 months, when we're getting ready to start high season, we do give them notice that we're going to attach a fine when you pay it. So you would be surprised. Some of our main primary businesses on the 300 and 400 block of Main Street are not licensed. So whatever the EBC and the chamber can do to assist us would be great.
or maybe even just communication plans?
He
What kind
has
of-
reached out to every business that does not have one.
What kind of
Several
fine are we
times.
talking?
What kind of fine?
There's the range. I haven't seen what was listed. If you put one in there, I thought most of the first offenses for most items are only like $50.
Yeah, it's usually 15, 75, 125. There are some, and I'm not sure if the business license is one of those very specific finding amounts.
It doesn't, it's not.
That's probably gonna be 50, 75, 125. And then municipal court summons. Potential, we have never done, it, but it's something options available.
One last thing for Parks and Rec. So I do want to thank Director Cosgrove for putting so much effort into the regulations around the capacity and the occupancy and the rules and regulations for our parks that some are always trying to mitigate and I guess be proactive and how many people are recreating in our parks. I like the idea of switching from dawn to dusk, but I noticed on the sign, the second portion of the sign, it still had the hours of.
It does. They've ordered a sticker that will go over.
Got it. Okay, I just wanted to double check that that sign was also gonna be revised to say dawn to dusk.
I think that is what his full intent.
Okay, great.
Okay, I just wanna say that I'm thrilled to see the plan for the Martin parcel. I'm really, really excited to get it started and done with Fishke here, sir, nice to see you. And I think working with the left hand is a wonderful thing. I think that even though this has taken longer than anybody anticipated to get going, I think having a solid plan that's based in reality with very experienced people is definitely the way to go. Let's do it right instead of do it fast. So, and I especially like the bit about educating people about the fairy forks. Because I know the kids are really attached to those.
So just to clarify about those forts, if I understand correctly, they need to be dismantled when they leave. Is that right?
We will do some education about that, correct?
They technically, they're on public property, they are not engineered structurally, so we could be, well, someone could try to hold us accountable for an injury if it were to occur, so I think they're looking at, that's the rule, is if you build one, you should dismantle it too. That's what our insurance provider is.
Any other questions about the administrator report? I'm sure you're done.
I mean, I have that.
Okay. Thanks. We'll move on to ordinances and public hearings. We have a second reading public hearing for ordinance 1143. An ordinance of the town of Lyons, Colorado, allowing residential solar installations of up to 25 kilowatt systems. Director Catlin?
Well, Mayor and trustees, so there were no changes to this ordinance from the first reading. It was again an ordinance that would allow residential, residential properties to install up to 25 kilowatts, raising that limit from 10 kilowatts. As was discussed before, 25 kilowatts is a point where we have to talk to our upstream electric provider, Mean, about how that gets metered and handled. So we wanted to make sure that anyone who wanted to try to go over 25 kilowatts would talk to the town, but it does raise that limit from 10 to 25, which we weren't sure exactly why 10 was put in back when it was, except that maybe it had to do with the rates at that time, and now it's been adjusted and the rate structure is not a concern.
Hey, are there any questions for Director Catlin? Okay, Brendan, do I open the public hearing now?
You do second reading, so
All right,
lively crowd tonight.
I know. So I will open the public hearing on ordinance 1143. Is there anybody in the room or online who would like to comment? Doesn't look like it, so I'll close the public hearing and entertain a motion.
I motion to approve ordinance 1143 on second reading. An ordinance of the town of Lyons, Colorado, allowing residential solar installations up to 25 kilowatts.
Thank you. Is there a second?
Second.
I second that. Thank you. So that's a motion and a second. Is there any discussion? I'll just say, I hope this gets us more solar.
That motion passes unanimously.
Thank you, everybody. Next, we have the second reading and public hearing of ordinance 1144, an ordinance of the town of Lyons, Colorado, approving a buy-sale contract with Gilbert and Kathleen Sparks for property located at 2156 Apple Valley Road. Is there a staff report for this?
No staff report. We're all pretty familiar with this one, other than the fact that in Colorado, we're required to sell property via ordinances, real property. So that's why it's an ordinance, not a resolution.
Questions? All right, I will open the public hearing.
It wasn't really a
Do you
question.
have a question?
I was gonna say, do we really want to sell it?
Jokes. Mr. Sparks, would you like to speak in the public hearing? Right. Oh, I think he is frozen.
I think that joke made it.
Okay, then, Mr. Sparks, would you like to speak during this public hearing?
No, thanks.
Okay, then I would entertain a motion.
I move to approve ordinance 1144 on second reading, an ordinance of the town of Lyons, Colorado, approving an agreement to buy and sell property located at 2157 Apple Valley Road.
2156. Yeah.
257. That's what I thought of 2157.
Gil will know.
Good job. Let's do that.
2157.
Okay.
Where are you? 2157, 215.
You better get that right.
Yeah, we will make sure it's right.
Okay, so should I make an amendment?
No, it's errata.
It's errata.
Direct staff to make sure that number is correct throughout.
We're directing staff to make sure that number is correct throughout.
Yeah.
Okay, so we have a motion, we need a second.
I second.
Thank you. Is there any discussion? No. Okay, we'll call for the vote.
And that motion passes unanimously.
Thank you. Congratulations, Mr. Sparks.
Thank you.
Can't wait to see what you do in
30 days.
30 days.
Oh.
Next, we have the consent agenda. Clerk Vasquez, can you please read the consent agenda into the record?
Yes, item 1 is resolution 2020. Oh, I'm sorry. Item 1 is resolution 2023-13, a resolution of the town of Lyons, Colorado, approving a temporary grading and construction easement to Lyons Valley Townhomes. This item was continued from the March 20th, 2023 Board of Trustees meeting. Item 2 is resolution 2023-15, a resolution of the town of Lyons, Colorado, approving a legislative process and agenda for the Board of Trustees. Item 3 is resolution 2023-21, a resolution of the town of Lyons, Colorado, approving the 6th Amendment to Murray Smith Design Services for the 4th Avenue pedestrian bridge design. Item 4 is resolution 2023-22, a resolution of the town of Lyons, Colorado, approving a proposal wildfire mitigation work by Left Hand Fire Protection District at 109 County Road 69, commonly known as the Martin Parcel. Item 5 are the March 20th, 2023 Board of Trustees meeting minutes, and item 6 are the April accounts payable.
Thank you. Is there a motion to approve the consent agenda? Thank you. Is there a second?
A second.
Thank you. Is there any item any trustee would like to pull from consent tonight? All right, and then I will call for the vote on consent.
And that passes unanimously.
Perfect. Thank you, everybody. Happy mitigating. Okay, so we'll move on to boards and commissions. We don't have a board and commission report out tonight, but I would like to appoint Jenna Harden to the Utilities and Engineering Board. With apologies for the delay, and Connie McGuire to the Economic Vitality Commission. All right, so moving right along tonight to general business discussion direction to staff on adopting the 2021 International Building Safety Codes. Director Kaplan, thank you for that.
You can sit here with us if you like. In case there's questions.
So again, this was to bring up the requested discussion or consideration to adopting the 2021 International Building Safety Codes. As you may remember, back in the fall We adopted the 2018 International Building Codes. We did adopt all of those. We did adopt the standard suite of codes. There are a few codes that we didn't adopt that are not standardly adopted, but we followed up with the standard set of codes, except for the International Fire Code. At that time, the Lions Fire Protection District was reviewing their possibility to recommend going to the 2021 International Fire Code, which is one of the modules of the suite of building safety codes. So we waited on that particular module to have their review of the 2021 codes. Also at that time, there was a request by the Sustainable Futures Commission to look into the 2021 International Energy Conservation Code in particular, but all of the 2021 building safety codes. So we have looked through the 2021 building safety codes. There's a lot of information there. For the most part, that I'm going to leave it up for specific questions where we want to go with that. I think some I tried to put in there was the legal concerns or the specific policy concerns of adopting the 2021 International Fire Code. Attorney Dittman can speak to that if you have questions based on how I worded it in there. But the International Fire Code is specifically ratified by a resolution after the fire protection district of a specific jurisdiction votes or approves it via the fire protection board. So it is slightly different from the way we do the other codes. However, I've tried to point out in there, I think we should try to include that in our municipal code so that if there are questions, it could be seen in our municipal code. Currently, it is not. And if you try to find out what we follow for the International Fire Code, it's a little more difficult. So I believe we could ratify it after the board decided that's what they wanted to do. And then we could also include it in our municipal code if we so choose to upgrade the other international building safety codes to the 2021. So that is listed in our code.
And so I can summarize it, overall, international building codes are adopted by the town board. There are two exceptions to that. One is fire code is done by whatever the fire protection district is, and we ratify it and suggest any modifications as necessary. The second one is the electrical code, which is adopted by the state, and again, we kind of ratify it via resolution, but it's really adopted by the state. They have no say over what it says. And so those are really the choices before. I do want to flag one other issue, and it's with the International Energy Conservation Code. And there's a state law that was passed last year, HB 22-13-62, which says that, basically we only have up until July 1st of this year to update our international codes. And if we do so after that point, then we have to adopt the latest version of the energy efficiency code. So if we hold off on this and want to, adopt the 2024 versions of the codes, then we'll be required at that same time to also adopt the 2024 International Energy Conservation Code. Whereas now we have more of a choice whether we adopt the 2021 or not. So.
Thank you for the clarification. Okay. Who has questions before we get into answering the questions? I have some questions. So when we talk about being solar ready, can someone explain exactly what that means and maybe estimate what that costs?
I don't know exactly what takes some of the technical specifications, I think, but it means you're having a house prepared to have solar panels placed on it. So you have the wiring, the conduit put in place. You have a home that is built. I'd have to look up all the list of items that are there, but in general, that you are building a home that you can then place solar panels on and place the inverter into the home and have it run on solar.
And so for the 2021 energy codes, can you remind us which municipalities have adopted those so far?
So I know I'm looking up Longmont, Erie, Fort Collins, Larimer County, Broomfield, Black Hawk, and Berthoud have the 2021 codes of those around us. I'm pretty sure I saw Aspen.
There's a lot more statewide.
Yeah.
But generally larger or some.
Okay. And I know it's really hard to say how much more expensive it is. But I'm curious to know if there's maybe a percentage estimate.
One of our building inspectors works with Charles Abbott and Associates, was just at a week-long building inspector seminar convention. And he was at one class where they were talking about the 2021 IECC, the International Energy Conservation Code. And they had estimated 17,000 for, I don't know the size of the house, a standard single family home.
They give you a per square foot number.
Right. It has
2,000 square foot, maybe it's pretty.
Yeah, it's like, I was gonna say 2,000 to 3,000.
Yeah, in line 3.
So when we installed solar panels about 5 or 6 years ago, it was about $1,000 a panel. And for our 3,000 square foot home, it took about 19 months. It really depends on how the house is exposed.
But
Yeah, so that's.
This
solar,
was
we're
not-
talking
yeah.
about the efficiency code, which is different.
The IECC does not require solar panels, or require solar ready, so it's a conduit.
And even there, it doesn't require solar ready unless a jurisdiction specifically ratifies it. There is an amendment. I don't think it's an amendment, an appendix on the 2021 International Energy Conservation Code. That is called solar ready residential. There's another appendix, solar ready commercial. And if a jurisdiction ratifies or adopts in an ordinance the 2020 code, they would need to specifically include that they are adding those appendixes. So you have the choice variation on it.
Which may be another reason why to make the decision now, because you want to have that choice past July 1st.
Got it. Okay. All right. So the questions in the memo: should staff bring forward an ordinance to adopt the 2021 International Building Codes? What do you think? Okay, so that's a yes. Should we include any exceptions to requiring fire suppression or sprinkler systems when bringing forward a resolution to ratify the 2021 International Fire Code? I would look to our resident expert and ask his opinion.
Mayor, members, trustees, and members of the staff, thank you. I could inundate you with statistics and facts about allowing the sprinkler provision of the code, which is putting in residential sprinkler systems into 1 and 2 family dwelling units, which is what was taken out of the adopted 2015 code. I'm not going to do that. I've got some salient facts that I'd like to just lay out to you that say that sprinkler systems do save lives. They save the lives of our citizens. They save our firefighters' lives, and they also save money in terms of water. If you look at the amount of water used in a residential fire where a sprinkler 1 head or 2 heads are activated versus what kind of water we're going to put on the fire when we get there, it's a tremendous amount of water. Look at downtown. There's 4 feet of water in the bottom of that building. You can only imagine how much water it took to fill up that basement with 4 feet of water. It's the same for residential. We're going to be pumping thousands of gallons of water on a residential fire, and I think that really in itself is something we'd rather not do. But the most important part about this is the residential sprinkler systems. They're called 13D, D being dwelling. they do save lives. They give an opportunity for the residents to get up or get out of the rooms that they're in and get out of the house. They don't necessarily put out the fire. They hold it in check until we can get there, which I think is a very critical point. But in a lot of instances, the home fires, those sprinklers do a good job of almost, if not totally, extinguishing the fire. So all we've got to do when we get there is make sure that the fire's out, do salvage and overhaul, and you really have saved the homeowner a tremendous amount of money on that. I think you've heard the horror stories about, when those sprinkler heads go off, it floods the building. That's stuff that you see on television. What's going to happen in a residential sprinkler fire is you're going to have one, maybe two heads go off. We do not put those sprinkler systems do not cover everything in the home. They're not in the bathrooms, they're not in the closets, they're not in the concealed spaces. They are where the residents occupy, living rooms and dens, kitchens, and most importantly, the bedrooms. Those are where those heads go, and there's where you see the saving of life when a fire does occur. Working in combination with smoke detectors, which are already in the code, it makes them just that much more effective. Without the sprinkler system, there's an old saying that smoke detectors wake you up to die if you don't know what you're doing once you wake up. Well, when you put that in combination with the sprinkler system will put that fire, either put it in check or extinguish it and then allow the residents to get out. So I think that's a very critical point. There's one other critical point I'd like to bring out, and that talks about flashover. Flashover is when you have a room and contents and it's totally involved. In homes that are being built today, and with the furniture that we find in typical homes today, flashover occurs in about the first 3 to 3.5 minutes. And I know that's a very, very short period of time, but I could show you countless films where they prove that that is in fact the case. The fortunate thing is we have a lot of older homes here in Lyons, and those homes were built with different material in different construction styles, and they typically have some of the older furniture. In those types of homes, you're looking at a flashover time of about 25 minutes. That's a huge difference in terms of how fast those fires grow. And so I think that's a very critical part about what sprinkler systems can do in terms of saving lives and property. They're not advertised as saving property, but in the long run, they do as well. So what else can I tell you about 13Ds for?
I think Administrator Simonson has something to add. There's one thing we talked about when we were preparing for tonight.
Yes.
And that is previous boards have looked at this and chose to exempt any remaining lots in town. That's what they did. We had a discussion at the staff level that we need to be cognizant as we head into our Boulder County IGA, that we have numerous areas that may be requesting annexation over the years, and those will be in that wildland urban interface. High on the hills and the mountains as that moves forward. And do we want those folks to have sprinklers? Versus feeling kind of secure here in town limits already. So that's just one thing I want you to think about as we move forward with these decisions is, I know the last two boards felt it was a hardship from a cost perspective and we only had a few left. But if indeed there is a chance we will be annexing properties in the dry hills, you might seriously want to consider this.
I do think that's an important part, and thank you for bringing that up. Those sprinkler systems will contain the fire to the residents, as opposed to letting it escape the residents and get into the interface area, which is what we live in here in Lyons. I'll give you a great example. In 2020, July, I believe, up on Courts in the Lyons about estates up there. We had a fire, fully involved home. And when our crews got up there, they did not fight the fire. They fought the wildland fire that occurred as a result of that. Fortunately, and our captain, that captain is on duty tonight. Fortunately, he did that. If he had tried to attack the home or the structure fire first, it would have been a different outcome on that fire. So one of the other main factors of 13D systems is keeps the fire itself when it does occur in the structure, as opposed to letting that structure get going and then spread to the interface.
Thank you. Questions?
No. Can you just confirm that we do have fire suppression systems going into Summit housing?
In the multifamily dwelling units, yes.
The single families, no, the other 16, 28.
I think for me, the biggest question, I think we need to do this, so the bigger question is. Buildable lots, do we want to exempt those, or do they? Not have a chance to do that, particularly thinking about the stuff just right down the hill from Summit, where they were wanting water taps, and we said, yeah, no, we can't do that unless you're really interested in affordable housing. What about that? So, yeah.
So it's the last 6 lots along McConnell Drive that are Lyons Valley Parks currently. Sorry, that's what she's referring to.
In terms of
Do we require sprinklers now for those?
no. And the attorney can correct me if I'm wrong. Once the code is adopted, then anything that occurs after that date would be required to do that. Anything that has occurred prior to that, and it starts with an application to the town for a building permit. If that has started before the code is adopted, they would be exempt.
You need an approved building permit,
Which they do
which they
now.
don't have. So if you were to adopt this,
You
this-
can't see.
if you were to adopt this code, it'd be applicable to those lots.
You can't see Director Kaplan's link, I don't think.
Right, I was just gonna add in, I suppose, the previous code didn't exempt specifically in-town lots. It was any single family or any duplexes to be built would not require a sprinkler system. And as was just said, to be clear, if a building permit is pulled, once the building permit is pulled, if you pull a building permit, you have everything, you're under the code that's in place at that time. So you might want to be aware of what's been talked about for construction that's not been there that might need a building permit. If there's affordable housing that has a duplex that currently would not need a sprinkler system. Under the new code, if they haven't pulled a building permit, if you did not make the exemption, they would need that.
I think it might be tough also to say these 6 lots get a special deal. You know, we're applying to everybody else without that sort of vested right that a building permit gives you, create a special class or scissoring, if you will, that would get, you know, the advantages of the old code. And the only other way I think you could do it is to put in a delayed effective date. And I think you'd run the risk of that law we talked about in the state versus whenever you adopt a new set of codes in the future, then you have to adopt the latest version of the energy code.
Why couldn't we say existing platted lots? Versus.
Yeah, it's just it's something we have to think about more. I think that was a direction, but I think it's problematic just from a code writing perspective.
So would this then apply to, say, somebody with an existing house gets a building permit to, I don't know, tear down a kitchen wall? Do they then have to put in sprinklers?
I believe it's gonna hit when you hit 50%. Is then when you have to do, there's gonna be a certain level that it's considered a completely new,
Substantial.
and I don't know offhand.
50%, I think, of the value of the home. So I mean, most of it's gonna be scrapes and redos or very substantial reconstruction.
Okay, I have a question and a comment. So do we know how many buildable lots we still have in the Tile Alliance? 2006?
Well, and again, then you're gonna say, but does that mean you're gonna have to add a lot, some stuff, you can't subdivide, because if we go with our changes in zoning and you allow lots to subdivide, they're pre-platted, and so does that change it because they went for a new plat?
I think if you assume that they don't subdivide, 6 is probably a pretty fair guess, 6 to 8.
Thank you for that. So we have very few buildable lots that could affect the views. And my comment, I guess, is just seeing this house being built at the end of my street over the past couple of years, that's probably worth about 2 million or 2.5 million at this point. I'm wondering how much they're concerned with how much it would cost to put a sprinkler system that would actually protect their lives.
They specifically fought, you may not have been involved for,
Right.
we had to build the, connect to the high pressure
Yeah.
water line to put, so they had the fire hydrant capacity to not have to build.
Well, and I would imagine that home insurance costs would be lower if you had a sprinkler system. Okay, so then the question is, should we include any exceptions to requiring fire suppression or sprinkler systems when bringing forward a resolution to ratify the 2021 IFC? No, okay, the answer to that is no. Should we look into options to try and reduce the cost while at the same time reducing the energy efficiency of any particular type of construction, such as affordable commercial, multifamily, ADU, or smaller size? Reduce the cost while at the same time reducing the energy efficiency. Why would we want to reduce the energy efficiency?
If they weren't required to build to the 2021, the idea is that the 2021 energy efficiency requires homes to have more insulation to be better, right? So in the long term, they might have savings. I was trying to point out that you could allow them to build to the 2015 or the 2018, I guess that we're already on 2018. So it's a 2018 code, but that home may not be as energy efficient. Trying to look at both sides. The constructors say, let us build the cheapest home. And a resident may say, well, no, I prefer to have the energy efficient home because in the long run, it may save me more money than I have to pay up front for the house. But being aware that allowing someone to build to the 2018 may allow for less efficient homes.
Well, and so I mean, it would make sense to me to think about, affordable housing and ADUs, as you mentioned. It's expensive. They're expensive to build. ADUs. They are not cheap. It's not just throwing something up there. And so I think to encourage, and they're smaller, so they use less energy anyway. And then we want to encourage affordable housing. We need to reduce the cost to do that. So how do other people feel that?
I hear what you have to say regarding affordable housing and ADUs, and I can be persuaded to think about cost at the same time. I'm looking at the Sustainable Futures Commission's recommendation to adopt the 2021 IECC. So I don't know.
And this, this could be a conversation for.
This is just to help us draft an ordinance to bring forward, so we don't end up going through it first.
We discussed the fact that we have 6 buildable lots, right? But those will be under an HOA, right? So at the end of an HOA neighborhood, so they can't have ADUs. So that's kind of all irrelevant.
But there are other places in town that they want to go.
Well, that's right, but if you build an ADU, does the building codes, I mean, if it's detached ADU, you would have to go with the latest building codes, right? And internally, no one's gonna do that just on the firewall, that's cost prohibitive. So you're rebuilding your house anyway. So, yeah, I mean, you're talking just about a small number of attached ADUs. I think the bigger conversations is before, a lot of this will play out in this before.
But
What is
there are people building detached ADUs.
Yeah.
And we've had a couple that have already talked about, and it looks like a living space to them, but when they go and find out they have to make it up to the 20, even currently 18, I think even one was to the 2015, was a significant cost to change a concrete block garage to something
Yeah.
that reaches that R rating.
That's a good point. Most people building detached ADUs are basically redoing the garage. So if we require them to tear down the garage completely and rebuild it back up, we're not gonna do that. I'm gonna say that.
And even just converting it. So I did want to try to mention one other thing to sort of think about maybe is even in the commercial space. When we have businesses and a building wants to change use, you are going to start to look at what they need to do just to change that use too. Or we have buildings where, okay, it's a big open space and now they want to put in 2 or 3 different types of businesses, and in particular, they're not similar occupancy codes. You want to have someone selling this, or they want to have their infusion marijuana over here. You may still have, they're going to have to meet the new building codes to be able to meet the occupancy. So occupancy ratings are a part of that. And somebody turning just a garage that is not living space into an ADU, just taking an existing building, not tearing it down. If you want to declare it an ADU, it has to now meet the occupancy of a dwelling unit. So they can't just have someone move into their existing garage. It has to become up to current codes to live there. So it wouldn't be, just want to make it clear, it's not necessarily just scraping, it's just taking that existing building and saying it's an ADU would require that.
Well, and to be honest, Director Kaplan, I think everybody here would agree with me that I really wish that we had the buildings on Main Street that burned had been up to code and had some kind of fire sprinkler system in place. So for me, trying to.
Well, we're talking about the energy efficiency right now.
Yeah.
Okay, sorry.
Okay, so we still need to decide if any type of construction should be excluded from the 2021 energy efficiency code, and if so, which kinds? I would like to propose portable housing, ADUs, and houses under 2,000 square feet.
A different level of energy efficiency, like 2018?
Yeah.
Okay.
Yeah. And then for commercial, I would actually love to hear from some business owners about this. I mean, I don't know. What I would hate would be for businesses to not locate in lines because they had to come up to the 2021 energy efficiency code. The building is so old that it would be just cost prohibitive for them to do that. Well, we don't want that to happen. So, you know, is there a staff recommendation about commercial businesses?
Yeah, it's a little tricky. I think you'd have to see what the difference is. Currently, they have to bring it up to the 2018. And so they're already required to do that. And some of these are so old that that's probably almost as expensive. So it's a little tricky to understand, and not knowing what the use is going to be. We can try to ask, and I think it may be more some of the property owners who then want to allow different businesses or different types of use of that business space. And it gets complicated. Then we get into ones that are allowing, you know, there's a use by right for commercial downtown to live up above the business, or to have that as a use by right. If they want to make changes or upgrades, do we want energy efficiency? I guess it's also the same for fire codes, might be a concern too, you're going to have there. So this isn't specifically energy. You could think about the concerns from the fire code perspective too, as far as sprinklers. I can try to check on that though and see what we can find out.
Yeah, I feel like I'd want to know more before we make a decision on that.
Directly to your concern about people not wanting to locate in lines because we have the 2021 code versus somewhere else. And what I would just mention, probably in part partially is because of this law that is mentioned, is that almost everybody's gonna be on the 2021 energy efficiency code, if not, within the next couple of months, within the next couple of years, almost assuredly they're going to be. And so it's not really what we call leakage, the concern of that. Just because that law mandates you to adopt it, essentially, whenever you adopt a building code from now until eternity.
And as far as the energy efficiency, most of the contractors here work in Longmont as well. Most of them are from Longmont. Doesn't it make sense to just be at the same level as Longmont? And I don't see somebody having a garage saying, okay, I want to build it into an ADU. I can do 2018 energy efficiency, but I can't do 2021 energy efficiency. I just don't see that. So I would just go with what Longmont is at.
What is long right now?
2021. As Laramie County is 2021, and while Boulder County is not 2021, they have their own energy efficiency code that actually has been set as stricter than the 2021. So really anything around this.
All right, so is there anybody opposed to just moving everything to 2021?
That's what we should do.
Well, and when we look at the list of cities surrounding us that have already adopted 2021 or their own, I feel like we're just playing the mainstream.
Does that give you what you need? Oh, solar ready, the appendices and the IECC for solar ready commercial. I don't feel like I want to require that. That seems silly. If somebody wants to put solar on their house, they'll decide when and how and where.
I'd like to add that it would be great to incentivize or encourage property owners living here in Colorado with so much sunshine to harness that solar energy.
Which is why we just increased it to 25 kilowatts. Now, do you have everything you need?
I do.
Okay. All right, so the next item under general business is discussion direction on the Riverbend workshop. Thank you very much for coming tonight.
Oh, thank you. I appreciate it. Mayor, trustees, as always, pleasure to come before you.
Have a good night and be safe.
Thanks.
Thank you.
Hope you have a boring night.
I'll take that.
Do we, so next on the agenda is the Riverbend discussion direction. And do we want to take a short break before we dive into that? Okay, we'll take a 5-minute break.
we're back.
Okay, thank you, everybody. Okay, so next is, discussion direction to staff on the River Bend workshop. So we heard a lot. I understand that the participants thought it was too short. It was nearly an hour, which is as much time as we allot to any workshop that we have. So would anybody like to start off the discussion? The question is, what, if anything, do we want to direct staff to do?
Okay, so working from the list from the bottom up, reduce the number of sewer taps required by New Casa from 8 to 2. I'm a little bit sympathetic to that. Maybe they do have too many sewer taps. You know, tiny homes are kind of a new thing, and exactly what tiny homes produce and consume as far as water and wastewater. I can understand it's probably debatable. So the question I have for Aaron is, if you have when this hotel gets built on Main Street, are they gonna have to get a sewer tap for each room? How does the hotel work, and how did we basically allot it based on the cost and times?
Right, so we did go through it quite a bit. I didn't realize sewer taps were gonna be on this part, a lot on the water to try to bring it back up. But part of it is you're looking at the tiny homes, right? Are they considered a hotel, or were they considered more of a home? So that was slightly different, that their home is not per room. From the town standpoint for the taps, really, to me, the municipal code is looking at the size of the water service. And what you have to pay then is based on that water service. I'd need to go back through and pull up notes. We did have it at one of the Board of Trustees meetings. I thought with the previous board, we went through everything for the sewer connections. And so I can review that and bring it back. But you are looking, so we're trying to have an engineer from the hotel tell us how much water can you use at your maximum, and that's the size of the water connection you need. So I know for Wicasa engineer Blankenship, there's a document showing they counted how many bathrooms they were going to have and how many of this they were going to have, and therefore it would be 1-inch size water or 1.5-inch size water listed on both of those. And then I believe they worked from that on the sewer. Having the individual sewer services, we could look back through why they're and it's, I don't know about taps. I think now we're talking about base fees. Are they paying 8 base fees? I thought I looked up in that there was a couple of other locations paying more than 1 base fee, but I'd have to go back and look. Like a building that has individual tenants is going to have the individual base fees, but I need to look that back up.
And I think before we get into the details of their four asks, I want to bring up that the first request of us was to take off our trustee hats. And if we do that, we are not doing our jobs. So I want to make that very clear that the trustee hats are staying on. Before we entertain whether or not we want to consider these asks, I think we also need to consider that they have never fulfilled their obligations under the MOA for their PUD. And it has been since 2016. So officially, I think it was a date in August of 2016 that if they didn't meet these obligations, the new zoning would not take effect. So essentially, it's zoned R2 at the moment in the last 7 years, for the last 7 years. Operating. So I would like to discuss whether, considering that, we want to even entertain these 4 requests.
Yeah, I hear what you're saying, and I definitely feel like until the zoning issue has been resolved, I don't think that we can actually discuss the plans. Because it sounds like they're operating illegally right now if you
or take this to the PCDC, is that right?
It's a violation of our zoning code, right? And their current operation. So technically we fine them $1,000 a day. during
Since
operation.
2016.
Well, there's statute of limitations again on municipal offenses, it'd be 1 year, $1,000 a day offenses technically.
So we've
We
just
don't-
saved them $365,000.
Maybe it's one way of looking at it. I mean, it's unusual. We would say, oh, yes, it's gonna be $1,000, a day for 365 days. But I think, during the heat, before we filed the lawsuit, that was part of the discussion. We're start finding you until we start taking care of these things.
And that was my question about the request for a third party, because wasn't there a judge involved in this lawsuit, and wouldn't he be considered a third party?
Yeah, so it was filed in the Boulder County Court, so a Boulder County Court judge was involved. It didn't reach what we call the merits, and go before a jury to full adjudication because we settled before they got there. But they raised as counterclaims to the existence of these 31 taps, allegedly, and it didn't go anywhere, right? That motion to dismiss didn't win. And so, in essence, at least from our perspective, that it already has been decided by a third party that that's just not valid. The board's always, can always say we want to hire a mediator or whoever, do it again, but it's unfair to say that it hasn't been evaluated by a third party because it has.
Well, and I want to make it very extremely clear to everybody who might be listening that in no way do I want to see this business cease operating. I, like everybody else, I think in town, love having River Bend here. I think it's a great asset to the town. I think they're fantastic community members. I also think that as trustees, we have to keep our trustee hats on and make sure that obligations are met.
I agree with you fully. I have worked with them in the nonprofit sector. They've given back to the community, whether it's for holding fundraising, events such as the Root Nanny. They mentioned several properties, several businesses, and one of our mandates in the comp plan is to retain businesses. So obviously we don't want to put them out of business. Obviously, we're not going to fine them $1,000 a day. But I do feel like if we have a code that we need to enforce as trustees, then I feel like that's what we need to deal with first.
Okay, I mean, you started off by asking which of these four you wanted to discuss. And then we said, no, we don't want to discuss them. But I do think to move forward, we should at least give them an idea of what we would be thoughtful about.
Okay.
And I agree, these 33 taps is a total red herring. That's 58 years ago, 52 years ago. We're not responsible for water rights from 52 years ago that have never been used. And so I want to just drop all of that. And I think legally we're totally fine, aren't we? Would you agree?
Yeah, if there was, allegedly bad actions taken in 2006, the time to bring that forward was in 2006. Or at the very least in 2008, when your last opportunity to do so, and that limitation would have been. And so legally, there is no avenue for them to claim that the town has really taken away property from them, at least with regard to the 31 light water tap.
Okay, so if we could just say that's off the table. Like I said, though, I think going to have a town review of sewer taps. Why not? I'm not saying what the conclusion is, but I think we would just in good faith review it to make sure that it makes sense. As far as these other ones, I'm not saying we should come up with a resolution. I guess maybe I'm asking the other people on the board, which ones do you want to just discuss in good faith with? Before just saying we're not going to talk to you unless we can go anymore. That's straight. I think we should open up with we should understand what we will talk to them in good faith about.
I think the only one I'm willing to consider is the sewer tax, since it has already been agreed to by an unbiased third party, being the judge from Boulder County. We've taken out the tax because it was so many years ago. And honestly, I don't want to revisit the Lake McIntosh shares because at the time we were in agreement with the city of Longmont and the Lake McIntosh shares were not an option. So we can't retrofit everything that happened before the agreement was amended in 2021. And we're setting a precedent for everybody to come to us and say, hey, you guys changed the rules. We'd like to go back and revisit what happened 10 years ago.
Yeah, the other one I was interested in looking at our agreement for. And I just need a little more clarification on the Macintosh. But yeah, you can start by that. So, before, it would be the only one I would, the first two, no, there's no, but it's just not, it's still incredibly irresponsible for us to do that. And I don't care how wonderful they are, it's just irresponsible for us to do a particular number two, or I'm certainly open to having a conversation with them.
I agree with number 4, and looking at number 3, is there a way that they would be able to pay the to get the Lake Macintosh shares?
Yeah, maybe I can clarify what number 3 is about. And so, and as part of the settlement of the lawsuit, we filed a complaint saying we need to dedicate CBT share to us, and as you are obligated to do so under the MOA. They couldn't find CBT share, it was claimed they couldn't find CBT share. So instead, the town decided to accept $70,000 in lieu of. They're now sent, what the town ended up doing with that $70,000 is buying 5 Lake and Macintosh water shares for the purposes of their future affordable housing opportunities or commercial development. We could potentially use those, for that opportunity. What they're asking for is to have those 5 shares back that we bought. With that $70,000, and at least from the legal perspective, that does not satisfy the intent of the settlement, which was, to fulfill their obligation in the way, which is we dedicate on water share. If we gave them back 5 shares, we were without that water share.
Yeah, can I ask that more specifically? So we took cash in those 70,000, but did we have to grab one of our CBT shares from the bank and dedicate it to Longmont for that tap?
At some point in time, yes,
Yeah, we did.
including the calculation of the overall covering.
So we lost one from the bank.
Yeah.
Okay, all right.
So I'm in the same agreement, so I think we should look at the sewer taps to see what the calculation says. The only question I have was in the, they want to amend the MOA. If they have to sell the property for payment of the taps, is there a dollar amount in there that says they have to pay? Or is it just the Macintosh share will be once it's all calculated out?
Well, I think it would depend on, they either have to give us CBT shares or whatever the new owner, if they were an affordable housing project, then they could bring in Macintosh shares.
There's 3 lots.
Yeah.
So depending on which lot.
It really depends on what it is who they're selling to.
I just didn't know if they locked in to make that, it had to be, there's some ridiculous amount from back then, it could be different now. Okay.
Well, I think that's something, I think it's important a little bit to understand where that's at. That's what I was trying to explain a little bit before. Normally a property comes in and they pay their cap fee to join the system and they give us the water rights for a 3/4 inch. It's 1 CBT or 1.4 Lake Macintosh. This MOU says these are not yours. The town is loaning them to you for now. And then if someone comes in the future, they would have to pay that just as they would if they were just coming in. So it's the change would be, from my understanding, is that those would officially be considered with the property now. They wouldn't just be on loan from the town. The property would now have 1 water rights or 1 acre foot, if we want to look at it, worth of water for whatever reason. And if a new business came in, and they needed a 4-inch water line, we would do as we're doing with the hotel. The hotel had an existing 3/4 on this property, an existing 3/4. They're going up. What's the difference? Like we did with the Evans Street properties. So any property coming in, you're looking at that. In this case, those properties would be therein of any water connection tap fee paid. That's my understanding of reading it, is it's loaned, and if a new property comes in, they would have to pay whatever is needed.
And just to add to that, it is very specific in paragraph 48 that the price for that water taps, and water share or whatever it is at the time of the sale to the new owner. And which means to me 2 things, one, whatever the current tap price is, that's what the new owner or they would have to pay. And then 2, if it was a property that was eligible for Macintosh water, then they could potentially dedicate Macintosh water instead of CBT.
Someone mentioned it was all
So one more question. So we're currently loaning them shares for the property.
Again, it's really complicated. No shares are anybody's at all. The shares, everybody in the town, it's town water rights. We own a portfolio and we've just looked at in the past what was required. It's not this property has their water rights at all. Right? It's just what Longmont has asked us for. So when we had new service connections go in there, yes, we had to do, it was sort of like what was happening with Spirit Hounds and the Lake McIntosh until they submitted their Lake McIntosh.
So the way to look at it is we loaned them taps. In order to operate those taps, they needed shares. And so we basically gave them the credit of the share to operate those taps. But no point to be actually physically give them the share.
Yeah, I know we never give them a share, but we have to dedicate shares to Longmont, right? Did we dedicate 3 more shares to Longmont?
Yes.
Okay, and so if they sold the property and then the new owner purchased or gave you money to purchase shares, those 3 that we loaned, we would get back from Longmont?
You don't get them back. The
No.
service
We don't get back,
connection
just
is
okay.
there.
We just get repaid. We basically, we get repaid for our giving away 3 shares. We're going to be dedicated to other uses.
Yeah, okay.
Yeah.
But right, there'd be no additional cost. You
Yeah.
could say you're gonna not get the other cost of somebody you're not gonna get water rights to come in, but we wouldn't lose them. And you're not gonna get the additional, you're not gonna get water rights, any additional. It's like lost income or profit.
We're getting repaid for our loan, 1, and then 2, under the MOA, we have to consider what the new use is of the property, whether it requires additional dedications. Yeah, so my understanding is that, part of the reason why that piece was put in was because there's anticipation that a future use might be a hotel. And if that was the case, it's gonna honestly need a lot more dedications, right? And so that's the reason why the Dragon was cautious around that. That way you couldn't say, well, you got your 3, dedications, we'll say 3 to be easy. And then we don't need any more. I mean, clearly you would need more based on the increased use.
So it sounds like a majority of the board wants to look at reducing the number of sewer taps required by WICASA. I would like to propose that we do not do that until the obligations in the MOA are fulfilled.
And just because I want to put on the record, if that's okay, and at least with regard to that issue number 4, the MOA would allow for that because it, when it talks about sewer taps for the first property, I'm trying to find the exact, for 501 West Main Street, it was 1 or more additional sewer taps as determined by the town engineer. So it did leave open the possibility that it could be any number of sewer taps based on use.
Okay, well, that's great to know.
I was just gonna, for a little bit of history, when it says as determined by the engineer, that was Mr. Blankenship. And that's kind of the crux of what they're arguing, because he determined that, so that the WICASA doesn't just have 8 taps. It's 4 to 1, every 4 tiny houses is 1 sewer tap. There's a house on there, there's the bathrooms, there's another house in the back. So it's a combination of everything. They're not all just tied to the WICASA. So it's yeah.
Yeah, and my recollection of that, and I'm happy if we want to have another engineer, if they want to hire someone to do it. Whatever, and we can too have our new engineer. But it was based on the same amount that we based our RV parking in Laverne Johnson on. We currently, every 4 RVs is equal to a sewer tap. So we use that same methodology. We didn't think of this as a 1 bedroom of a house. We looked at it as 1 hotel room. And a hotel room where people can use water and sewer freely, and oftentimes people do. And it was the first ones. So I'm certainly open to having another look at this as well, but I agree. We have to now figure out, do we have to go back and start rezoning? Or if they're currently R2. And we need to, if you're okay with this kind of picking up where we left off with that with them, it should be fairly easy to get that over the
But I do think we should look at we're talking about taps, but then they were talking about the number of base fees their account pays. Right, so if we're going by this calculation based on water usage, how much water usage the hotel has, is that going to determine how many base fees they have to pay? Or is it the size of the water service that determines the base fees? And that's where I thought they wanted us to look into it more and make that determination.
Well, and Aaron's right, commercial base fees are calculated differently. They're calculated monthly on the amount of water that's consumed every month. But that's where, when you're saying, is it going to be based on the number of consumption? But there should be a calculation for the hotel, the new hotel, just like Mr. Blankenship did for Riverbend. Okay, there's 4 faucets, 4 bathrooms, that's how they calculated it.
But in addition, they have 8 separate base fees. So all the businesses do pay. I just want to be clear that all the businesses do pay that commercial rate.
Right.
All the businesses do not have that many base fees that I'm aware of.
Is that because that every other commercial business or most only have one tap versus they have multiple?
Well, again,
Right.
that's like a 3/4 inch service connection, or is it a 1 inch service connection, right? We do charge taps. Taps is usually just to be talking about that initial fee that you pay to get connected to the system.
Right, and that's how Jim calculated it. It would take 8 sewer taps to run everything that they're running at Riverbend, the bathrooms, the house, the tiny homes, and that's why they pay 8 base fees, because they were allocated, because they had 31 sewer taps, and they said, we'll give all of those back except what Jim says is required. And he came up with that number.
And I believe we did have.
And they did away with the other sewer taps. They didn't pay base fees on those. And now they just pay for what the calculations came
I
out to.
believe that's what they agreed to, because otherwise, to hold them the same as we did everyone after the flood, if you want to hang on to those 31 taps,
You had to
you
pay
have to pay
base
that
fees.
base fee every month. And no, they didn't want to do that, and so this is what we agreed.
So it sounds like everybody was very thoughtful. Okay. Good. So it sounds like they requested we redo the calculation. What happens if the calculation makes it higher?
Then they'd have to buy some sewer taps.
Yeah, it is. But I feel like food has to finish first.
Well, and one of the criticisms that has been levied against this board is that we do not have the proper respect for the decisions made by previous boards. And I would like to say that I think previous boards were right, particularly about this issue. And I would like to not look at anything until they fulfill the MOA.
And can somebody clarify for me which zone they should be labeled as?
So,
If it's not R2.
so right now, because they've not fulfilled the PUD, it's just our basic goal R2, right? And so the PUD, yeah, and so the PUD is an overlay, so it would just be PUD, R2 PUD, or PUD R2.
A duplex on a property.
The PUD can be anything, pretty much, just additional flexibility.
So does this need to go back to the PCBC then, so that PCBC can determine?
So-
it's overlaid?
That's what I was asking, are we okay picking up where we left off, or do we want to start over?
So I think there's a couple different ways to look at this. One is, they, got their PUD, it was approved, right? That approval had conditions. Over time, between 2016 and today, most of those conditions have been met. Some more easily than others. The very final last one is a final Mylar of the PUD, basically documenting what that PUD looks like.
The drainage.
And it's somewhat dependent upon, disputes over what the drainage should be. That's the reason why they haven't done it. And so once that, drainage is figured out and then it's put on a Mylar, that PUD is done. It's effective. That's one way to look at it. How do you enforce that? Well, there's two ways really. One, as I mentioned, it's a municipal code violation, every day that is not come to compliance. Two, is it technically a violation of the settlement agreement? contractually as an owner, they're obligated to provide that. Finalized Mylar within a reasonable amount of time. And so up until probably the end of this year, we could technically sue them for a violation of the settlement. That is, second enforcement mechanism. Third, I think you could proceed with a board initiated rezoning of the property. Based on the fact that the PUD is ineffective. And then, we would be in the driver's seat as to, what that looks like pretty much. But I think the cleanest one would be municipal code enforcement until you fix the Mylar.
So I was, like I said, it could be a municipal code enforcement in order for them to finish. I mean, obviously, we don't want to go there, but can you say, could they have, oh, it takes 30 days, 60 days in order to complete it, but not the next step is the violation. How long would it realistically, ideally take to get out?
Right, it depends how far they are. When I got involved a couple of years ago, the only thing came up with that was still left in that list was the storm water improvements that needed to be done. There are some sand filters and others that need to be put in there. I know those have been permitted to move forward and that they could do what they proposed. So if the construction is underway on those, then it depends, where their contractor's at in the process. If they don't have a contractor yet, then I don't know what it might take to get a contract out and do the work.
Yeah, and is that all the their cost?
Yes.
It's work they have to do in this people.
Yes. And then file the Mylar.
And I think, at least my understanding is that some of it, we originally in 2016 had a plan to do the drainage this way because this is what our plans were, but our plans may be different in the future, so we don't want to do the drainage that way anymore. And if you want to do something different, that requires basically a redo of the. Yeah, and so the last board, they came in and said, can we just not do that? And then the answer was no, do it as you said you were gonna do it. And that would be more or less my recommendations. Like if you have future plans that are different, let's get it up to the way it was supposed to be. And then let's talk about what the future plans are. Because then they require not just, a PUD change, but all sorts of other, amendments to the MOA to accomplish those different plans.
So how do we find out where they are with this project?
I can ask them. I'm talking to Mr. Whip on his electric chargers, so I can see where they're at when I talk to him.
Okay, so just to be super clear. It sounds to me like the direction of the board is that we are not going to, that the only thing we would be willing to talk about is the number of sewer taps required from Free Plaza. And we will not do that until the conditions of the community are met.
Yes, and I think that if we are looking to review the number of sewer taps, we have to be equitable with what we have decided for ourselves in the town of Lyons and the municipal campsites. As a compliment.
Is that accurate for everybody?
What about
Base fees would be the only thing I would want to be very specific. I think Aaron is saying he would like to look at, it won't be just taps, it'll be taps and base fees, just to be clear.
Yeah.
And I think the last piece, this is what sort of municipal code enforcement would you like to see if the Mylar isn't done and the PUD is not finalized? Whether in addition to saying we're not going to work with you until you finish the PUD, whether it be a threat of code enforcement.
Time frame
Yeah.
to get that done by, or we will.
Go ahead, Tim,
I
first.
was gonna say, why don't we wait and see how far they are along first?
Okay.
We're not in a rush. Then we can wait and decide the next board meeting. If we have information as to how far they are along, because you don't want to give them an unrealistic time. Next step, if they just say, we know we couldn't hit that anyway, so it's just not sliding the this.
So maybe the message or the response is that, you know, just so you know, there's the option of code working out there and the board will evaluate that if there is, you know, progress on moving towards the PUD conclusion.
I do want to be collaborative about this.
Absolutely. But we also don't want to be doing this in 2 years. Because the
Yes.
PUD is done.
That is correct.
And it's also, you know, as we, you know, our shop does the code enforcement stuff, sometimes it's really bad, is that, you know, we've hammered on people for code enforcement. For not complying with zoning. And it's not a legal precedent, but a bad operational precedent, say. You can go 4 years out of compliance with your zoning, or saying other people, we're taking this to court for, you know, 4 months of non-compliance.
Yes. Other comments?
Well, I just want to quote from their memo directly here where it asks that they would like to be treated as all citizens. They would like to feel like they're being treated as all citizens are treated equally. And that should be a core value of our town. And I want to reiterate that. But do you think we need to treat everybody equitably? What's the board, whether it's surtax fees or base fees or municipal code or enforcement? I think that's what we're about.
Okay. All right, then we will move on to trustee reports. Trustee Olson, since you got up there first.
All right, SFC has no meetings since we last met. Their meeting is actually next Thursday. So the EAB met. We actually had the presentation from the code enforcement officer for the fire mitigation. That was fantastic. Went into a lot of good detail on it. Went through every slide, so it was good. And they're very happy with what's going on with mine. What else? Yes. Kathleen Sands also was there for Lions Climate Action Group, and long discussion with her on the spraying. We used to get involved. Well, that was really it. The two presentations to the ball. Long time. Yeah, that was really it. They discussed the steam read machine. Still moving in dental on that. Hopefully, see if it can work to get rid of weeds without using chemicals. Discuss the grants about the transition to electric mowers. Yeah. That's it.
Any questions from President?
Yes, so I think everybody received my report for the Housing and Human Services Commission, which met on March 13th. We'll be meeting again next Monday. The good news is that the Boulder County Area Agency on Aging has hired a mountain resource specialist, which is great. They're supposed to start a April 5th, so I feel like that's this week. And we're hoping that we will attend our next meeting on Monday. Luckily, in the interim, we have had a representative from the Boulder County Area on Aging have some kind of presence on Tuesdays and Thursdays at the Wall Center. And let me see. Oh, I had a question for Gio Bravo, the program manager for community living at Boulder County. I was asking her about a caregiving symposium, like the one offered in Lions several years ago, entitled Aging Well Alliance. So we were asked if we would like to represent mountain communities at multi-agency meetings involving complex cases, and I said yes. I was also curious. I had some with our public information sessions around the Lions Valley townhomes. We've had a lot of requests for 1 bedroom, 1 bath units. And specifically around the Walt Self Center, I think there are 12 units currently at the Walt Self Center. And somebody was interested in knowing how to contact the person responsible at Boulder County Housing Partners that is in charge of the wait list. And it sounds like it could take up to 8 years to get one of those 1 bedroom units. And those are for residents 62 plus. So yes, it counts 62 minus 8. And if you're in that age frame, then that's when you want to get on the wait list. Also, I'm waiting on a report from Boulder County on the past, present, and future. It's a report they put up every 4 years, and it's due, I think, in May. So you heard about the mental health update. LEAF I think they finished their interview process at the time of this meeting. They had already interviewed 9 candidates. 2 candidates had experience with addictions in youth. So that's, they're hoping to offer programming for youth mental health and substance abuse. And then you heard about the roadmap for behavioral health in the minister's report. Let me see, I talked to them about the increase in marijuana tax. They were all for it, except they were hoping that it could be used specifically to fund a human services fund, which would power prevention, education, and training. Actually, the mental health specialist at LEAF, who's a commissioner on the commission, said that she was having a very difficult time finding grant money for youth programming. So if anybody knows anything about grants for youth programming, she would love. And I was the one who had asked the co-responder to come up with some numbers so we could see how many are regarding substance abuse. So in that report, we saw the number of calls, but we don't know how many of those are linked to substance abuse. And I was wondering what kind of problem we have during this. Let me see. And then, yes, so I think next, well, actually this month, we're looking forward to hearing when the application window will open for Lions Valley Townhomes. And that's really exciting news. And we will be updating everybody who is on that information sheet as soon as we know something. So that's all from the Housing and Human Services Commission. Any questions about that? Okay, going on to EBC. So EBC met on March 15th. We're looking for a new commissioner, but you just appointed one tonight. So yay, Connie McGuire for stepping up and thank you for approving her because it's important for us to have a forum so that we can, the commission can make decisions moving forward. Let's see. We talked about the Lure agreement with Moss Rock. We talked about the Colorado 36 and Broadway update. I'm not sure. I had in here, hopefully the BOT can agree to a contractor by April 6th. I don't think we have any news on that today, do we? No. That'll be the next meeting. And then we talked about action items. So they're actually really proactive about the EBC goals. And then Cam gave an update about 402 Main Street. And we also talked about the increase in local marijuana tax, but they didn't feel like they had enough information to give a recommendation. I know that one of the participants here tonight is interested in doing a case study to define what business friendly means in Lions. And they would like to work with the EBC on that to see how the town can help businesses survive hard times. Our next EBC meeting will be on April 18th, and I asked for the visitor center to be part of the agenda because we need to find a solution before Memorial Day when we hope to have that staffed. 2 other things that I attended. So on March 30th, I was with Mayor Rogan at the Longmont Museum for Doing Democracy Day, a program I hadn't heard of before, but really cool program where 65 St. Vrain Valley School District students, including 3 from the Lions High School here, met at the museum to discuss with local leaders, I guess, issues that affect teens or that might be, that they might be interested in. There was a discussion around fentanyl, school safety, screen addiction, social emotional learning, how to spend the Bronco money, and homelessness. So it was really interesting actually to hear from the Lions teams and also to hear from the school resource officer who was there and kind of reassured me that I was listening to the fentanyl discussion, and he reassured me that every health class should be just dealing with drugs specifically. And they are talking about not taking any medication from anybody, whether you have a headache, whether you need Advil, because it could be laced with fentanyl. It could be an accidental overdose. And yes, every school does have Narcan and every teacher has been trained to use it. And I guess it sounds like the Longmont teams want to spend the $1 million that Longmont's getting from the Bronco Stadium on a recreation center in East Longmont. When it comes to homelessness, they really think that we can get ahead of that by creating affordable housing. It always comes back to affordable housing somehow. And then that same day, I attended a community session at the library around the Lions flyer. So I know trustee Edding here takes the Lions Flyer, your regular passenger. It was all about the wrap design. Because apparently I did not know this, but the graphic design studio that's working with Boulder County on this wrap design has can actually prove that through marketing and wrapping these buses, you can increase ridership. So right now, the average ridership is about 7 people per day, and the maximum capacity is 18. So and we had a couple of youth from Lions who had great suggestions around art, artistic ideas and texture and all kinds of things. And I think we're gonna have a really great wrap and hopefully that'll increase ridership. So that's all.
Yeah.
So I'm very curious, can you go back to how do you evaluate the board as business friendly? Like, how do you do a study on that? I'm really curious about that because it's a term we all throw around. But how do you measure what board really is business friendly or not? Because I've seen previous boards that I thought were very business friendly thing, all the guys became business friendly. Yeah. I'm very curious.
Yes, and actually, if I think back to my notes, I think I actually put in parentheses what that person meant by business friendly. And I think what I wrote down was inexpensive or affordable. So it was really like, how can we make it more affordable for businesses to do business friendly? That's what I understood by business friendly, but they'd like to
Is the board going to see this instrument before you apply it?
what's that?
They can bring it back to the board before they start applying this.
So I think they're talking about doing a case study
Case
right
study.
now.
It just one since.
No, so, I think it's a good discussion to keep having, but I don't think it's something for it doesn't seem like it's the right thing for the EDC to define, although I would be really interested to hear their recommendations.
So right now, it sounds like it's a discussion. And it sounds like the chair of the EDC is open to having this discussion. I think the discussion has started. And so I'll be happy to bring back whatever recommendation the EDC has after following this discussion. I'll be following it closely too.
Unfortunately, I was out on holidays during spring break. But Aaron, did the UEB meet? And is there anything from the utility side that you speak to? Please.
Right, we're meeting now, so no, yeah, I was out also.
You were out as well.
No, there was no UEB meeting last.
Okay, so there was no meeting last night. Okay. Unfortunately, I missed the students last night. But I do know, and I think I reported this last time. They're gonna probably stop around the end of school. I don't think they'll meet throughout the summer, but they have elected Dusty Sommer. I think I mentioned that last time to chair next week, and they are working on recruitment for next year. So.
If I can add a comment to that. So one of the 3 teams who was at the Doing Democracy Day, he's a junior. 2 of them were seniors, one of them was a junior. And I said, okay, could you please have him, Otto, speak to Desta about being part of the student advisory committee? Because you could tell the teams who were there at this session, they're obviously leaders in the community. So yeah.
Thank you. No, any questions for Justin? Okay.
So since we last met, Parks and Rec has not met, so nothing to report.
Mr. Williams?
Same thing.
All right, so I want to talk for a little while here about SB 23-213, referred to as the Housing for All bill.
I'm glad you're doing it and not me, so.
There we go. So tonight we passed the legislative agenda. And in the legislative agenda, we talk about preserving local control. This bill takes local control away from municipalities, particularly like ours. I'm going to give you just some highlights. And this is a 150-page bill. There was a CML call last week that 350 people attended, and not one person was in support of this bill. So if this bill passes as is, we would no longer be able to set our own prices for water tax. We would no longer be able to require that ADU owners reside in their primary residences at all. We would no longer be able to administer any design standards Setbacks would be set at 5 feet in all instances, regardless of WUI code. All residences would be able to build ADUs by right, including HOA governed communities. We would have to submit a housing study every 5 years at our own expense. Lyons would likely be the only town in Boulder County besides Ned to retain any single family zoning. So imagine what that is going to do to the home prices here, which are now $1 million. There are no provisions in this bill for any guarantees of affordability. None. It hands all oversight and enforcement over to DOLA. Gives them apparently $15 million to go and do all of this. So CML obviously opposes this, and they're very clear in that. Metro mayors and Dr. Cog are in the process of discussing. And Metro mayors is going to come to a consensus decision, I think, by April 10th. So the way this process is going to work, and Brandon, correct me if I'm wrong, is this it's going to be in committee on this Thursday, April 6th. If it passes out of committee, then it goes to the House for a vote, then it goes to the Senate for a vote, then it goes back to the House.
Then depending on how many changes are made to a conference committee, basically make a final version and they get voted on again.
Okay. So there's time. I do know that we were promised a robust discussion and amendment process. And apparently that robust discussion and amendment process was a Google form that we had 48 hours to fill out as mayors. That had to talk about exactly what we wanted to change, give them wording and an explanation. So this is seems like it's being ran through. So I am going to testify on April 6th. I welcome company. I know Trustee Dottie was potentially interested. The thing is, I don't know what time yet. And I don't know how long it's going to take. It could be a very, very late night. I don't know. But there's a letter to sign on to that I will sign on to. And I also want to think about for the next meeting doing a resolution as a board opposing this. I think what CML is suggesting, and I think it's a good idea, is to oppose this bill, go back to the drawing board and work with municipalities. You know, when I speak about this, I'm going to talk about what exactly Lyons in particular has done and is doing. So it's kind of like, give us a chance before we get these unfunded mandates that are essentially going to be tied up in court for years. So I don't know, Brandon, would you add anything to that?
No, I think there's pretty significant constitutional issues with this too, in terms of, you know, the Colorado Constitution uniquely reserves a lot of power to municipalities. It says that basically it's a local function, cannot be performed or delegated to a special board or commission, of which DOLA is one. And so in DOLA, it doesn't really have the capability to do this or really the desire to do this, which so it's interesting. The staff or anything, I mean, you have massive overhaul that DOLA does. And so it's an interesting concept that is, you know, density above all else is basically the idea. And so there are gonna be fights for a long time, you know, if this goes forward.
So do we have to be worried about this at all, or is this just, do you think it's just not gonna happen?
I think you gotta worry about it. It's being pushed by the governor's office pretty strongly. I mean, it's definitely coming in red or current policies, you know, from the wheelhouse. And again, the concept is density will solve all the problems, basically, with housing affordability in Colorado.
Regardless of what.
But it does seem eventually R1 zoning will go away at some point. I just don't see it being here 100 years from now.
That, I mean, that could be the case, but maybe a more nuanced approach might be a good way to do it. Right?
Exactly. So don't you think we'll end up with much more nuanced approach, something similar to California or Oregon?
Hopefully, I mean, right now, we only respond to the bill we have on the floor, which is 158 pages. Hardly anyone's gone through it line by line. You know, most of the articles that came out originally, they were only working off what they were told, more or less was in it. So there's a lot of, we're still discovering kind of the impacts of this.
There's a lot of ambiguity in the bill. CML stood up a website about the bill, which is a really interesting read, and I encourage everybody who's listening to go and take a look at their website and their analysis.
I want to thank Mayor Rogan for going and testifying on our behalf and standing up for our town. Because so often I've noticed in these, multi-agency sessions, it's it's our voice gets lost, because we're that small rural town. And it's so important to stand up for what's important to us.
And you're welcome, and there are a lot of small rural towns, many. Okay, so
I'm just wondering, how is planning commission, how are you going to get them involved? And just so you know, you could have a member to attend as well, and that will not help to the quorum.
great, I'll talk to Mayor Pro Tem about that. And I would love to get them involved, and there will be other opportunities to testify. Because I think this bill will make it out of committee.
I'm thinking that you can talk about it.
Okay, so that's that soapbox. Administrator Simonson and I met with Mayor Peck and the Longmont City Manager, a very preliminary meeting to discuss the possibility of Lions and Longmont partnering for affordable housing. So we'll definitely bring Housing and Human Services in as the discussion moves forward. I want to know if we were ever able to get Lauren click that spreadsheet of LEHC expenses that she was looking for.
I know the finance director was working on it. There's only like 3 items, so.
Okay, so I think, yeah, just so that they know how much money they have. Investment. And then finally, I would like to do some education and reminder about off-leash dogs. Because it's springtime and there's a lot of them, and so it might be good to educate the community that dog park and like.
I noticed there was only 1 citation for dog at March in March. And I know I've seen more than that.
Yeah. Okay, legal update.
Yeah, so thank you for taking on the land use legislation. I was planning on, speaking to some degree. And there's another piece of legislation that I've been heavily involved with as part of CAMO that may have some impact on the town. We're hoping, kind of like this bill, where it's a very large, kind of crazy bill that we can tear down in some way. But essentially what it does is it changes the structure for the Clean Energy Plan legislation that came out a couple of years ago. What that plan does, which, CAMU was very supportive of, is reduces greenhouse gas emissions by 80% by 2035. CAMU was very supportive of that. Instead of a process by which, the largest municipal utilities, Colorado Springs and PRPA, basically submitted plans to the Air Commission on how they would achieve that. Some of the environmental nonprofits did not like those plans. They thought they were too vague, essentially. And so they have created a bill, among many other things, that says that PRPA, Colorado Springs, and now MEAN would have to go back and basically reprove their plans through a different authority. And so, and with a whole bunch of process around it, which is going to be very expensive. And just redoing what's already been approved by both the PUC and CPHE. And so MEAN is CAMU is very opposed to this, and that it takes away a lot of local control. And basically what happens is under this new process, if it's turned out to be good enough, similar to the DOLA bill, it would allow CDPHE to basically choose how you acquire your resources, which is a big problem. And it's even a bigger problem, for us if our means our supplier. How does the state of Colorado get to tell MEAN, a municipal agency of the state of Nebraska, how to acquire resources? And so it's a major problem. It's a kind of a pie in the sky type of legislation in a lot of ways. But CAMU is fighting very hard to put some sense into this. That we've already done this. Why are you trying to make this complicated? We're very much in support of the emission reduction targets. Where you gain by implementing this process. So there's a whole bunch of other stuff in the bill that I'm not going to talk about. It's not relevant to us, but that's the big CAMU piece that I've been a big part of, and that CAMU will continue to be a big part of moving forward. Next, I want to talk about the Muti Yoder a little bit and update on that case. So we had a conversation with an attorney from Chase, who is the lender for that property. They said that, you know, the sale of last week did not happen. That basically, Ms. Yoder is, you know, pursuing all of her rights possible and delaying that sale. And so now they're waiting on a court order, basically forcing that foreclosure sale to happen. Once that order happens, and there's no timeline on that, then there'll be a 35-day period, which the sale will definitely happen at that point in time. And so, you know, Chase has told us that they will tell us when that court order happens. So in the meantime, she did come in for a permit for the deck. And so I think that's moving forward. Aaron's been on top of that one, but they want to give an update.
Any questions for Attorney Devin? We'll see you at the State House. Summary of action items, please.
Okay, number one, I have the lease is to be issued a deadline of April 15th. The Board of Trustees Subcommittee is to notify the Leaf Board, and Administrator Simonson is to notify the staff liaison. Number two, the board consensus is for Administrator Simonson to sign the opioid settlement participant agreement and forms, and then to be followed by a resolution to ratify that. Number three, Trustee Daddy volunteered to work with staff for use of the Visitor Center. Ordinance 1143 passed on second reading. Staff to correct errata on ordinance 1144. That ordinance also passed on second reading. There are to be no exemptions for sprinkler systems when ratifying the fire code. Board consensus to adopt the 2021 IBC suite of codes. Is that correct? Sounds right. Yeah. The board is willing to review the number of sewer taps required for WCASA, and they will do that when they have a completed PUD. And then Director Kaplan is to ask Mr. Whip and Riverbend how far along they are with completing the PUD, and then bring that back to the board. There's to be a resolution drafted in opposition to Senate Bill 23-213 for the next meeting. Follow up on whether the LAHC received the spreadsheet on costs and budget. And the mayor requested public education on dogs at large.
Make sure you miss click on the spreadsheet.
Yep, LAHC spreadsheet, got it.
Anything else, Administrator Simonson?
I don't.
Attorney Devin?
I did forget something on the legal update. I can quickly go back there for a minute, and that is an update on lodging taxes from Airbnb and VRBO. After spending many weeks trying to chase down attorneys to those places, we finally heard back today, police from Airbnb, that they're willing to enter into some sort of agreement to help facilitate collection of those lodging taxes. You know, holding the rights that they have to pay those taxes. They're willing to help facilitate the collection of those taxes. So I know that past board, and maybe even this board has asked about that. So I wanted to update you.
Great, thank you.
Follow up on something from the annual report that I forgot to mention. It's regarding golf cart registration. I just want to remind the staff to communicate to the residents of that when registration is available.
What happened this afternoon?
The link is.
Okay, do we want to take a break before executive session? We want to keep motor or not? Okay. Is there a motion to go into executive session and have the motion printed out right here? If anybody would like to read it.
Okay. I motion to move into executive session being conducted pursuant to CRS section 24-6-4024E and 24-6-402 4D for the purpose of determining positions relative to matters that may be subject to negotiations, developing strategy for negotiations, and respecting negotiators, and for receiving legal advice from attorneys representing the town of specific legal questions, and specifically determining negotiating positions and strategies regarding the town's energy cost savings contract with Honeywell International Incorporated for the new wastewater treatment plant, and obtaining advice as needed from legal counsel on related legal issues.
Thank you very much. Is there a second?
Second.
Any discussion? Great. Vote.
And that motion passes unanimously.
Okay, great. So we'll just, do we need to lock the door?
We need to close.